Okay, so good morning, everyone, and a very, very warm welcome to the IT Legal Summit 2020. And it is day 2 of our virtual summit. This webinar is brought to you by Lex Witness, India's first magazine on legal and corporate affairs. We hope everyone is keeping safe and is healthy during these difficult times of COVID-19. We thank you all of our participants for joining us on a Saturday morning for this webinar on the IT Legal Summit. Allow me to also bring into you an all-new world of Lex Witness Virtual, that is lexwitnesslive.com, which encapsulates all of our digital initiatives so far across an array of industry sectors and practice areas. Amongst many, the Lex Witness 8th Annual Information Technology Virtual Summit Edition is our debut towards our flagship events moving into the virtual world. And after having completed 7 successful editions, this edition is scheduled for today. We also had our first day yesterday, live on your screen, as you can see now. The summit has been one of the most preferred knowledge sharing and networking platforms for the industry professionals ever since its debut edition. Well, before we go ahead, some basic house rules. You can ask your questions live at the end of each session if you have any questions. You can also use the raise hand icon to join and wait for your turn to ask live questions at the end of every panel discussion or a session. And you may also put in your questions, post them in the question and answer box at any time during the session, and we'll take them. If we are unable to take any of the questions, don't worry. We at Lex Witness will get back to you and will ensure that all of your queries are answered to you. So let me also now go through the agenda, take you through the agenda of today. We are going to start with a panel discussion on e-contracting today and tomorrow. Are you geared up? That is what we are going to be discussing at 11. And this is going to be followed by a focused presentation on India's road to digital tax by Mr. Vasan MS, who's the Senior Vice President, Global Taxation at HGS, which is going to be followed by a session on e-commerce, a heavier cart now at 12:30 p.m. So please stay with us during this webinar. We have some very interesting sessions lined up for you. And let us now begin with our first session, a panel discussion, as I mentioned, on e-contracting today and tomorrow, geared up. So let me also introduce you to our panelists for this first session. We have Neha Mayavanshi, Field Compliance Officer at SAP, who will be moderating the session. Neha graduated from Nalsar University of Law, Hyderabad, is working as an in-house counsel in the IT industry, a corporate lawyer at heart. She's currently serving as the Field Compliance Officer for SAP subsidiary in India. She spent a good 10 years of her professional career negotiating the most complex technology contracts and now ensuring that SAP India stays compliant with the world-class compliance management program that SAP has. A thinker and ponderer of many world issues, including climate change, the world economic order, politics, and everything that make our world go round. Welcome, Neha. I'm going to move on to our next panelist. We have with us Mr. Kundan Kumar Lal, Vice President and Company Secretary at KES Corporation, legal counsel and company secretary with over 20 years of experience in the listed and unlisted companies, represented engineering, manufacturing, IT, and emerging growth technology companies in the field of corporate and secretarial, labor, indirect taxation, real estate, intellectual property, setting up units in DTA and SEZ, and litigation matters. We also have with us this morning Mr. Navroz Palekar, General Manager Legal at WNS Global Services, with over a decade of work experience in the ITES sector. Navroz has been a versatile and agile professional across geographies of North America, Americas, Europe, European Union, and Asia Pacific, and has a demonstrable track record delivering tactical solutions as a techno-legal commercial business partner for global geographies and corporations whose turnovers range from $400 million to $40 billion. And Navroz has effectively managed key accounts with a customer focus, business, and result. We also have with us Sapan Parekh, who is the co-founder of legality.com. And Sapan is the co-founder of Legality, as I mentioned, a digital document execution program, as head of the sales and operations. Sapan plays a key role in guiding top Indian enterprises in digital transformations of their contracting processes. So welcome to all of our panelists here this morning, and I'm going to now hand it over to Neha to take it forward from here. Thank you.
Thank you, Samriddhi. And good morning and welcome to everybody. It's an absolute pleasure to be here. It's a weekend morning, so special thank you to the panelists and to the participants who are joining in. Without further ado, I think we should just dive into this very interesting topic that we've been handed and we have the pleasure to discuss this morning. Contracting is something that is, has been going on in history for a really long time. Humans figured a way to contract, to be able to put down the promises that they made to each other into some sort of documented form. I think it might have, taken its own life when paper was invented, and as humanity moved forward with inventions, with new ways of engagement. But today we are faced with another way of engaging, and that force which has brought about the change is absolutely the pandemic, right? For us, all of us, contracting, if you look at 10 years ago, perhaps e-contracting was not a topic that we discussed. About 5 years ago, the change has been that e-contracting is something that we considered as good to have, best to have, when we have the resources to invest in the right solutions, we would want to do it. But it was not the absolute essential. It was not the need of the hour. So it may have slipped on priority lists. However, the pandemic has made this topic front and center. We have to now confront it. We have to find a way to transform and find a way to change. At least that has been, our experience, and that's probably what we're going to talk about. We're also going to talk about some very interesting aspects, because the way in which we've had to scale up and change, literally at the speed of thought. There are so many questions that come about, and the questions on validity, on what does it mean? Does it have the essentials? Does e-contracting cover the essentials of contracting that we learned back in college or in law school, where we were taught to think a certain way? And we'll think about how e-contracting addresses all of those questions and doubts that we have as lawyers in our mind. So I have a great set of panelists. Thank you for joining. So Navruz, perhaps I start with you by asking you, what has your experience been with respect to the pandemic? How has your experience changed? What have you been seeing?
Hey, thank you, Neha, and a very good morning to everyone. I think, Neha, there's one thing that you very rightly said right now. Change has been at the speed of thought. And ever since the pandemic hit, every day has been a challenge for not just our industry, but I'm seeing it across the globe. You don't know what's going to be a new day starting tomorrow, and what are the new challenges that you're going to face, because at the end of the day, we as a company, as a service provider for providing business process management services, were actually, how do I put it? We had to literally think on our feet at the very last minute, because of the way governments were imposing lockdowns. We had to implement our business continuity plans, and generally speaking, business continuity plans mean that you would be providing services from a different delivery center. But in this situation, the other delivery centers were also equally impacted by the lockdown. So we had to kind of think at the speed of thought, and ensure that a work from home solution is implemented at a very urgent level, especially for customers whose businesses were predominantly based on online transactions. They were the ones that would have been impacted the most had our employees not been able to go to the office to process transactions. So WNS has been, probably one of the first organizations across the country to kind of move close to about 30,000 laptops and desktops to our employee residences so that they could implement the work from home solution. The biggest challenges have been certainly the security aspects, because at the end of the day, when you're working out of a delivery center, you have a secured environment. When you have a work from home situation, it is a completely different ball game. You have, there is, apart from your laptop or desktop, which is company provided, what is the other security measures that you can implement? So convincing clients to implement that, and of course, at that point in time, the world literally moved at a rapid pace in giving approvals. I have never seen approvals coming in from clients at such rapid pace, where they say, okay, yes, please go ahead, implement the work from home solution. We would like to, ensure that there is continuity of business, because that was the primary thing, primary focus. Um, so 90% of our clients, we've seen that we were successful in implementing those solutions. Of course, we had to, as was prevalent across the industry, where several key industry players made sure they highlighted residual risks associated with the work from home solutions, which clients had to acknowledge, because at the end of the day, it was a trust factor with the clients. We had to ensure that work carries on. The residual risks that were associated with most of them were ideally or were generally based around the data security protocols, IT protocols, etc. But knowing that WNS, the way we have been providing services to our customers, we ensured that all our clients' fears of any security protocols being breached were allayed, and we had to ensure that all our employees also gave specific written declarations saying that they will adhere to the policies of the company, which are also applicable to them in this pandemic situation where they are supposed to work from home. So there was a seamless transition. Past 6 months, we've just seen excellent results. Very few clients actually coming back and having any issues with the protocol. Some of them did have, we had to discuss specific service level agreements that had to be renegotiated, considering that it is no longer in a controlled environment. So those are the nitty gritties that had to be tied up. Those are the loose ends that we had to tie up. But yes, this pandemic has been a great learning experience, and I would say that. And I was listening to some of the panelists yesterday as well. Everybody's saying that this is a new normal. Tomorrow, I would not be surprised if the word pandemic gets dropped from a force majeure clause, because the world has pretty much overcome the concept of a pandemic in ensuring that business continues. So you're still working. That's another interesting topic that we should be addressing as an industry.
Absolutely. Thank you for that. And I can't agree with you more about the rapid pace at which we've had to learn to change and learn to adapt. I sometimes think of the coronavirus as not just a pandemic. Perhaps we need a new phrase, because it was not just about the pandemic and the medical situation, but it was also about government restrictions and government lockdowns. And when you read the word pandemic, you usually don't associate it with government-related restrictions and travel restrictions, etc. So maybe we need a new phrase for it. I don't know. Just putting the thought out there. So maybe I'll move to the next panelist, Mr. Kundan. If you could tell us, did you see any experience of stopgap solutions that people are putting in? Because we've had to go from position A to position B in the flash of a second. So did you see a lot of change, and how are people coping? What has your experience been?
Thanks, Neha, and good morning, everyone. I think it's a very good question. Based on my experience, which I have for the last 15, 20 years in legal field. And I will start that, when I started implementation of legal workbench, in Cummins, I'm talking about 15 years back. And at that time, we had just shifted from the DOS to window, and we are preparing that all, and then there was a legal department. As a legal department, we arrived that let us have a online legal workbench, right? Which they will give the input, and then it will pass to the business head, and then head will give the approval, and the agreement will approve online, right? So I have that experience implementation in Cummins, and then later on, when I joined Kennametal, I put up that complete e-contract management system, except the e-digital signature. Everything was approving, and everything happened through that software. So, and after that, in Sonata, we implemented even that electronic signature with the agreements, right? And end-to-end solution, agreement executing e-contract. So if I see the last 7-8 years development, because of the IT development, in information technologies development, Indian Evidence Act itself has been amended, right? And plus this Indian Contract Act, right? So if you see that every individual, I'm not talking about only corporate, every individual nowadays, they are signing e-contract on daily basis, right? If you sign any end-user agreement on your cell phone, that is e-contract, right? You are agreeing to the terms and condition. Even you are not signing digitally, but you are accepting their offer, acceptance, consideration, whatever mentioned in that. And that is itself, it says that we are signing e-contract on daily basis, right? So now I come to the validity part, right? That what's the difference? Firstly, the traditional agreement and e-contract, right, which you are executing. So from Indian contract point of view, Section 10 and other applicability, right? If e-contract having all characteristics what's required under Indian Contract Act, that contract is valid, whether it's e-contract or traditional contract, right? Like offer, acceptance, we call it to, right? Then we call legal consideration, right? Lawful object, parties competent to contract, right? If these parameters meet, right, then it becomes a valid contract under Indian Contract Act. And I draw attention here also that Section 10A has been inserted in Information Technologies Act, right, which makes validity of contract e-contract, right? And then the Section 5 of Information Technology Act, which give the validity of signature, whether you do e-signature or you do facsimile signature or you do that primary and secondary key signature, which we take class 2 signature, class 3 signature from the authority, right? So once you sign with that signature, and if it's having the audit trail, right, from which computer it has been signed, which IP address it has been signed, it is recorded, and then it becomes a valid contract. I said that I have recently, in my previous experience also, many international contract we have executed through DocuSign, through EcoSign that Adobe provide, right? Many such companies provide that e-signature. So that there is what we require for e-contract, there is a originator from where it is going, proposer, and the person to whom you are sending, right? They are accepting it. Once they accept and confirm your acceptance, it becomes a valid contract. So even I have seen that various court pronouncement and other things, if you see, whether Supreme Court, High Court, and local court, right, they have established that even email in certain cases, email communication became a contract, that someone has given offer on email and that has been accepted by other party. And if they are able to show under Section 65A and B of the Indian Evidence Act, there is such evidence available, then it becomes a valid contract, whether it's in the agreement format or not. It doesn't matter. Even the email communication becomes a contract now, right? So nowadays, if you see that because of this pandemic and all, many things the people are, even the court are saying that notice is being sent to WhatsApp, it is accepted and it's binding, right? That is also a contract. If the person is not attending the court, even after giving the notice on WhatsApp, they will be amount to that X party. That person has not attended it, right? So nowadays it become a so prevalent, and pandemic has made many such thing, it's evolving, right? And that's why what I see that The technology is to be evolved, already evolving, like blockchain, artificial intelligence, it's coming into picture, right? So that the legal folks can just electronic contract management system, they will put it, and then they can search whether what clauses it's having, right? Whether data privacy clause is having, or search it whether it's what's the jurisdiction part, right? The I'm coming to again the third point, that under Indian Evidence Act, the 85 section 85A, right, has been inserted to make electronic contract valid, right? So from Evidence Act point of view, from information technology point of view, and from Indian contract point of view, it has all the characteristics which make the contract completely valid, completely executable, right, and binding on each party who are party to the contract. Right. So that's from the validity point of view.
Okay, thank you so much, Mr. Kundan. Sapan, you come from a background of providing e-contracting solution. I have two questions for you. Firstly, did you see any industry trend among your customers and with the pandemic? And second is a question that's posed in the chat section, in the Q&A section, and I think it was, it's a very pertinent question, had to come up in our discussions, and that's about e-signatures and the validity. What does the law say? I'm sure you've looked into these aspects because it's so core to your solution. So give us your thoughts on that.
Right. Thank you, Neha. It's wonderful to be here. Thank you, everyone, for joining us on this Saturday morning. Neha, answering your question, actually, given that this is the first time in our lifetimes we are seeing pandemic, the results were, of course, surprising. So even before we had lockdowns in place, we saw a massive interest coming from the legal and the business community because people saw where this trend was leading, right? China started lockdowns since January. So the interest already spiked, I would say, even before the lockdowns, right? And this interest was just in terms of ensuring business continuity, as Navroz was pointing out. Once the lockdown hit, a lot of transactions, now I'm just talking about the transactions, the legal transactions, the large ticket size transactions, which got stuck because of the lockdown, right? Because authorized signatories abroad or authorized signatories somewhere quarantined, not available in offices, right? So we did a spate of very large ticket transactions, like for JM Financial, for Orchid Pharma, Dhanuka Labs. These are 1,000 crore contracts, right? These are not what one would assume end user licenses for downloading a software, right? So we saw a massive shift in the first couple of months of businesses and legal teams adopting e-contracting solutions. The advantage, of course, they've got in terms of time, convenience, cost, security, enforceability, all of that came with it. But that was an eye-opener for a lot of clients we spoke to, that lockdown actually pushed them into moving towards e-contracting, right? And once they experienced this, now we see more and more companies adopting it for their small and large contracts. So there's a massive amount of onboarding we are seeing, and interest we are seeing, and queries we are seeing. And then webinars like this actually help educate the industry on what could be the possibilities coming out of the pandemic. So I think it's very positive in terms of possibly very few positives coming out of pandemic is people adopting digital solutions. E-contracting is just one small aspect of the larger move towards digitization. So that's the first one. Second, in terms of e-contracting, just a bit of a flavor here. All e-contracting solutions are not cut from the same cloth. It actually depends on your use case. It depends on who your counterparty is, how much cost you want to bear, how seamless you want the solution to be, right? For example, as Kundan was mentioning, we have end user licenses are also e-contracts, but you wouldn't want to implement that for 1,000 crore contract, right? You would actually want something more enforceable, where the identity of the parties are also very auditable, right? So I would categorize them in some brackets. One is sort of a click wrap agreements, which can be done for a very low risk contracts, right? Which we see in software downloads. That's one, which is not what primarily is used by legal teams or business teams. Second, I would say, is global electronic signatures. As Mr. Kundan was pointing out, these are DocuSigns and Adobe's large giants based out of the US who provide solutions globally. These are global electronic signatures. Third comes at Indian electronic and digital signatures. These are electronic signatures which have a heightened enforceability in India. India recognizes us something which goes beyond global e-signatures in terms of enforceability, as is given in 65A, in 85 ABC, where it says secure electronic signatures in India have higher enforceability, right? So that's the third step. And the fourth is the email-based contract, which Supreme Court has also recognized. So there are many flavors to it, and depending on who your end party is, whether it's a corporate, whether it's a gig worker who doesn't want a very complicated journey, it depends on what you want to get signed and what is the risk factor and what is the cost associated with it. So that's the flavor. And in terms of validity, e-contracts are absolutely valid in most scenarios. The only exceptions, as given in the IT Act, are very clear, right? One is for conveyance of property or conveyance of interest in property, or be it in terms of will or power of attorneys, right? So there are 5 exceptions which are delineated as a negative list. You just need to be careful that you're not e-signing those. And otherwise, I think everything under the sky can be digitized through e-contracting in India.
Hey, thank you, Sapan, for that, and thank you for slicing and dicing the topic for us, because clearly you've put a lot of thought and effort into it, so you know it with much more clarity than perhaps some of us. At least for myself, I can speak that it was very helpful to know that categorization. So Navroz, I want to ask you the next question, and again, great questions coming up in the Q&A section. So I'm going to perhaps direct that, one question that's coming up on jurisdiction. Now, you are from an IT outsourcing industry. So I'm presuming that most of your clients are international clients. You perhaps are always in your negotiations, having great negotiations over the jurisdiction clause. So tell us your experience with e-contracting, with respect perhaps to the jurisdiction. How do you handle that aspect, and what is your experience in negotiating international contracts?
So, that's a great question. And, probably I should start with the example that I gave, when we were discussing yesterday. The example that I gave about we were dealing with a company in Qatar, and the governing laws were that of UK, so of the contract. So, of course, the contract does, with the governing laws being recognized e-signatures and the e-contracting module. Um However, being a Qatari company with of course, stakes of the government being involved in that, they still believe in having hard copies couriered across for initialing each and every page, signing it off. So it was basically the traditional wet sign process. Um, of course, so there comes the conflict of whether the governing law, the applicable law. So the applicable law of Qatar certainly required that contracts be wet signed and have hard copies be retained. In that scenario, and to Sapan's point, he made a very good observation that the world is now moving towards digitization, but traditionally certain organizations, certain arms of the government still require that things be documented in the form of hard paper. And till that gets eradicated, we will never have a complete shift to digitization. With, I would say, probably 95% of our clients being, overseas, all our contracting has always happened over email, has been executed using DocuSign. We absolutely promote the usage of e-signatures purely because, one, it is extremely convenient, it saves time. Countries across the globe have recognized, courts have recognized the validity of e-signatures. And not just that, you're saving the environment. You're not printing out like hundreds of papers.
Absolutely. Yeah. Thank you for that. And thank you for bringing the environmental aspect. It's really interesting that, to think that because everybody is not moving at the same pace. We may have countries that are, still not up to scale, don't have the laws in place. For instance, like Mr. Kundan pointed out, the laws that we already have in India, whether it's the IT Act, the Companies Act, the Evidence Act, the changes that we've had, perhaps other countries don't. And so in international contracts, especially when you have, companies from several countries, how we all going to scale up, how we all going to find a meeting point is indeed, a moot question. And thank you for sharing that, real life example with us. Mr. Kundan, there is another, topic that is consistently coming up, and I think that's again a very important topic from an Indian contracting perspective, which is the payment of stamp duty. And how are we going to address? What have you seen? I know you exchanged some interesting anecdotes with us yesterday. What are you seeing? And then how do you think people are scaling up? How do you think we're going to deal with this in the e-contracting way of living in the future?
Sure, Neha, I think it's which is coming nowadays, basic question for e-contracting, how we are going to stamp the proper stamp duty. First of all, I would like to mention that for any legal contract, right, stamp duty is an additional part. It does not make the contract invalid, right? So contract is valid subject to condition that the authority is having power to impound the document which is improperly stamped, and then the person has to pay the penalty and and then make it, again, impounding can be relieved. However, the question comes why we should do the improper stamp duty. So nowadays, if you see that many states, they have given the facility to make the online payment, right? For particularly the smaller value contract, I'm saying that generally what we do, now you will not believe, we are in a staffing industries, right? And almost on daily basis, we execute 50 contracts, right? And monthly, the volume of contracts is very high. And recently we have implemented a complete end-to-end contract solution in our company and our group, which facilitate, and now every legal person is working from home, executing the contract, doing all the things. As far as the stamp duty is concerned, in Karnataka, you can take the e-stamp, and that you have to give reference in the agreement that it's being executed through e-stamp number this, right? So it will inbuilt that stamp duty has been paid on that contract by this e-stamp number, right? So that to make the duty, because it's only state wants the stamp duty to be paid to the state, otherwise contract is valid. Contract is, it's not that if a stamp is not paid, contract is invalid. So what I've seen, and for big value contract, what we do, we pay the stamp duty through like a stock holding corporation, or there are many other agencies, right? You pay the stamp duty, take the contract, and then execute. For example, I tell you, for millions of rupees, we issued a share certificate, right? Allotment of shares, we made it. Earlier, it used to be revenue stamp to be affixed on the physical share certificate, do that, all those things, right? Now, whatever stamp duty comes, you need to directly pay by DD or by transferring the accounts through to the stock holding or state government. And just you need to mention that it has been paid constituted by this number, that challan number or that stamp number, you need to put it on the document. In the same way, any agreement, if particular state, whatever stamp duty applicable, you can procure the stamp, put the stamp number in the agreement, and make that a stamp as an integral part of that contract. And it can be like, through PDF editor or something, you need to affix that stamp along with the contract and keep in your depository. So it will make a contract valid even in e-contract executed. So I have seen that, but there is no doubt there is certain challenges also. In some states, there, still that stamp paper is available in the physical form, right? The person has to. So that will still how we need to, so contract you need to execute. So it will be for some time, but I think of late, because of this pandemic, it has been, people have learned, and the state is losing that duty also for that and all. So they have to evolve their, and put the technology in place. Recently, if you remember, there was a announcement from introduction from National E-Governance Limited, right? You remember that they have come with the digital document execution process. So the person can execute the e-contract, which is valid e-contract, and pay the stamp duty through that method. So the many state, it's a central government project. It will take time, but I think in next 2 years, 3 years, right, that that will happen, and even all the stamp duty people can go directly and execute through that method, pay the stamp duty, and it will be a valid e-contract. So that's coming the other way.
Yeah, thank you for that. Very insightful to know what are the changes that are coming about, and how we are addressing in this, in this new phase of life, especially the stamp duty aspect. Sapan, I want to ask you. There's this question about in the Q&A section, which I thought was very pertinent to this discussion about how does DocuSign work? I mean, people want to understand how is e-contracting working, because I think some of us are saying names of certain e-contracting solutions, signature solutions. So can you give us a little bit of idea about how that works? And also from the stamp duty perspective, as a solution provider, what do you see is the best solution? How are you addressing the need for your customers in this area?
Got it. Yeah, Neha, I'll answer the question, the second question first, just to maintain the order. Just a couple of points here. I think the problem a lot of businesses will face, and which is why they come to the legal teams, is they're not executing a few documents daily. They're executing hundreds and thousands of documents, right? So just take, for example, an NBFC or a bank, right? We have several banks and NBFCs as clients. The challenge with following, and I think some states in India have the e-stamping solution through SHCIL. What that requires you to do is requires to pay the duty online, but there's a catch in it. The stamp paper has to be printed and then consumed, right? So that's the problem, right? You pay the stamp duty and you pay one document at a time, and then you print it out and then you scan it, then you make it part of your document, as Mr. Kundan was saying, and then you take it forward, right? Now, this is fine for 10 documents a day, 20 documents a day, 50 documents a day, because you have a large enough team to do it. But when we look at banks and NBFCs, you have hundreds and thousands happening every hour, right? The way to ensure that stamp duty is paid digitally and uniformly across the country, because every state follows a different regulation, right? So we have built a very unique set of product which helps you procure stamp papers from across the country and digitally use it for your documents. And this happens through what is called as APIs, which is application programming interfaces, which happens on a click of a button. There's no payment you have to do on the fly for every transaction. There is no complication with respect to wastage of stamp duty. You don't have to enter details within the contract itself. So it's quite seamless, and it's used by banks like Federal Bank or Airtel Payments Bank or large NBFCs who do hundreds and thousands of volumes daily, right? So on stamping aspect, I think volume is critical, because if it's low volume, I'm sure you can send a runner to the bank to get the stamp paper. But when we're talking about high volumes or multiple state stamp papers, you don't want to have that workforce to add to your cost, right? So that is one aspect. The second aspect is how do we ensure with respect to DocuSign, you mentioned similar e-contracting solutions. I think the philosophy of all e-contracting solutions is the same, right? They want to make things as seamless for you to use. So everybody follows a different sort of a technology. Like DocuSign follows a sort of a technology which is more accepted in countries like United States, which is the electronic signature there, where you get an invitation, and I'm sure a lot of people have used DocuSign here. You get an invitation on your email ID, you click on it, you put your signature through the mobile phone, and it reflects on the document, right? And they capture the computer details and so on and so forth, right? India, thankfully, allows for even heightened security. So India has two other solutions in addition to this. It recognizes such solutions, but there are heightened solutions like DSC token signing, which I think somebody's mentioned in the comment section. DSC token signing, which a lot of directors and authorized signatories have. Even more seamless than that is what is called as Aadhaar e-signing, where you just key in your Aadhaar number, completely secure, completely isolated, when you enter the Aadhaar number, you get an OTP on your mobile, and a digital signature certificate is generated on the fly, which means this signature cannot be misused. You cannot lose this signature because you get OTP on your mobile number. And this transaction can be done. The most important thing that is possible, and this is what makes it attractive for the banking and finance industry, is the identity is verified. It's not on the basis of email ID or a mobile number. The identity of the individual gets verified at the time of signing, and it happens every time. And we've built solutions on top of this to ensure that misuse and frauds can be reduced. Just for example, we've clients talk about certain instances where if I send an invitation to Neha to e-sign, Neha, instead of using her own Aadhaar number, may use her mother's Aadhaar number to sign. Maybe it's by mistake, maybe somebody else took your mobile device to sign, maybe there is fraudulent intent, right? So how do we prevent those sort of things? So solutions, we build solutions which prevents anybody but Neha from signing the document, which actually saves a lot of compliance and audit time, which ensures there are no mistakes in terms of disbursement of loans, in terms of who the vendor is, who's the authorized signatory of the vendor. A lot of these things can be automated, which comes to the core point on why you should adopt e-contracting, because I think e-contracting by itself, we should not assume it's a good thing, right? Because people have to internally also sell this idea of digital transformation, right? So we need hardcore reasons as to why it's a good thing for that organization, for that use case, right? So most important, of course, is in terms of auditability of the transaction. There is higher enforceability when you do e-contracting than physical. People may find it surprising, but it's just easier to enforce e-contracts than physical documents. And of course, you save costs by not having the extra workforce to do the paperwork, to move documents around, and importantly, storage, right? Where do you store contracts for 10 years? Because while you can scan and keep it, the original anyways remains on paper, which means you have to store it. But when you do it e-contracting, use an e-contracting mechanism, the original itself is in a digital format, right? So there's no question of storing physical copies. So there are lots of solutions in terms of e-signing, which you can adopt depending on the business size. There's a complete suite of e-signatures you can use on our platform at least. And in terms of stamping, you can stamp documents across the country without limitations of which state has e-stamping. Maharashtra, for example, has what is called as ESBTR. Other states like Telangana have what is called as franking. So cutting across the state complications, we provide a simplified single interface for stamping and e-signing.
Thank you so much. So I think we have perhaps somebody going to be asking questions, because we have one person added in. Okay, while we wait for that, for the last portion, probably we'll take 5 minutes to take 5 to 10 minutes to take some live questions. But before that, I want to just say for a moment that now I'm in a compliance role. And what we see from an investigations perspective, especially when we have, say, external investigators who are wanting to look at transactions that we've done, or we have internal investigations happening on transactions, specifically in areas where there are high risk areas, government contracts, for instance. It is what we find most challenging is the ability to track transactions, what happened, what was the offer we gave, what was the acceptance, what were the terms. Now, when the whole thing is digitized, it's very clean. Our systems we have internal systems that have communicated the price to the customers. We're able to track that. We're able to track what contracts we generated and when got signed. And it's just, everything's right there on the tool, versus in the past where we've had situations where we've had literally contracts come out of the woodwork that we weren't aware of. It weren't on our records. There could be site commitments, opening up a whole gamut of scary things for us, literally. So it makes all sense that we rely more and more on digitization, because it just gives you a cleaner record of what's happening, and hopefully we can also circumvent illegal activities or unlawful activities in that sense. Shall we ask some live questions now? I think we may have about 5 minutes.
Neha, we have around 12 questions that a lot of people have posted and upvoted in the Q&A box. If you can address to them one by one.
Okay, Okay, sure, we could do that. Some of the questions have already woven into the conversation that we had.
Sure.
So maybe I'll ask a few questions and ask our panelists if they've had any experience with that. I see one on demand promissory note. Can it be executed via e-signatures? Anybody wants to take that? I don't have personal experience on that area. Sapan?
Sure, Neha. DPNs as demand promissory notes cannot be e-signed. That's an exclusion under the IT Act. So that can't be done. What we have seen clients do, and this is the solution for a lot of clients we've suggested, is you can change the nature of legal instrument. Instead of having a demand promissory note, you can change that instrument to a legal agreement, a declaration, an undertaking. You can see what alternatives, depending on what kind of agreement you're signing, what alternatives exist for the demand promissory note. So we've seen clients, because they want to digitize, because of the many advantages of it in terms of enforcement, we've seen clients move away from demand promissory notes to something which is an alternative.
Okay, thank you for that. Navroz, I just want to ask you one more question because it's out of curiosity really. With the whole pandemic changing the nature of contracting itself, what are you seeing in terms of contractual clauses going through changes? Which ones are coming in the forefront? Also, how is it change? How is the e-contracting behavior changing with respect to your customers? That'd be something that we'd like to know.
Sure. So, in terms of the change in contracting, of course, the force majeure clause, which is probably one of the most important but neglected clauses pre-pandemic, where it was just considered as one of those clauses which you need to have in the contract, and you move on from there. You don't discuss it much. These days, we see a lot of discussions happening, not just on the force majeure clause, but also on the business continuity plan, or the business continuity management, or the disaster recovery plan clauses, and not just that, the actual schedules that would identify a solution that would need to be woven in to the contract if such a force majeure event hits. The other aspects that are currently coming to the forefront are, and which I touched upon briefly at the beginning, was around the residual risks associated with carrying out work in such situations. What would be the service levels? What is the impact on service levels? What are the information security protocols and measures that are being implemented by the companies? All of these need to be listed down. With this pandemic, there's certainly one thing has changed is the way technology is now being used to implement security measures across equipment that is being or is being loaded onto the equipment that is being used to carry out processes or work from home situation. Our risk team is they have been on the forefront of this, and I've had some really interesting conversations, and with the new technologies that they're bringing in, it's just amazing. They told me that if tomorrow I'm working on my laptop and I just do a print screen, immediately there's a notification that's going to get triggered to the security team, and they're going to start an investigation as to why did I print a particular screenshot, and that actually gets replicated at the back end on our office servers. So those are the kind of things which are now going to be at the forefront. How are you going to monitor the usage of cameras, right? How are you going to monitor the usage of mobile phones? Earlier, in a controlled environment, our employees are not supposed to take mobile phones onto the process floors purely from a security standpoint. That's a requirement from a client. Now, we highlight that risk to a client today, but the client is, clients are now getting more and more educated about the fact that there will be certain risks that need to be prevented. So the liability structure associated with such risks are also going to see a major change. while you are responsible for the acts or omissions of your employees, to what extent will you take on that liability, because they are not under your direct control or under your direct supervision. So those aspects are getting heavily negotiated these days. So we are seeing a huge change in the way contracting is being done. Transactions are being negotiated. So it is an ever learning process, for the past 6 months. Every day we have a new challenge that is being thrown at us.
Neha, please unmute yourself.
Yeah, sorry. Yeah, I was on mute. So I just want to, ask Mr. Kundan. We talked about the validity of contracts, and we talked about the elements of a contract and a valid contract. We have a question here about undue influence, and how do we ensure that a contract is not e-contract is not signed under undue influence, and I think it's about the competency of parties signing the contract. So could you let us have your thoughts on that?
So, see, one of the essential parameters of the contract that it has to be signed by free consent of the parties, right? And that is essential part of the Indian Contract Act. And if any contract, so nowadays, if I tell you that, for example, the social sites, right, Facebook, many younger person, right, they are signing the Facebook, and they are showing that they are older than 18 age, and then they are signing the agreement and entering the data, right? So whether, now the question comes that whether that agreement is valid or not valid, right? So still it's a lot of debate and challenges on that part, because certain times, suppose you take IT contract, and where many software license, there is a open general license and there is a license, right? And that many companies which are using the open general license in their software, they need to disclose that they have taken open general license from there, and that has to be disclosed. I don't know how many companies they follow it, right? But that again come the free consent, right? So when you are subscribing like a small contract, I'm saying in the user license agreement, what I have seen the tendency, nobody read the terms and condition, what is written there, right? They just go and accept that. They say that, okay, so whether it will be taken as a free consent of the parties? Yes, in the agreement, it will be considered as a free consent. I shared with you one case which I handled in my previous organization, where the company signed a contract, US contract, just like a end user, a license agreement, something, and that big name, I'm talking about I'm not taking the name here, but the online contract was signed, executed, right? And that contract was having clause that it will be automatically renewed after 6 months or 1 year time, right? And then you will be liable to this much amount payable. Now question comes that whether that clause is valid, because sometimes you do not read the terms and condition and then you write, acknowledge it. So the best part, the consent, before giving the consent, you need to read the terms and condition, because nowadays it's very easy that the people sign the contract, right? So you need to read the terms and condition, whether, and if it is required to be changed, you need to negotiate with the service provider, right? And then change it. So the free consent or not, online, if you are giving the consent, signing, if you are you can dispute, but it's very challengeable, because ultimately we resolve the issue with that service provider, because that argument does not go well, that we did not see that auto renewal clause and we are not agreeing, we are not ready to pay. And now if you are entering into such contract international level, there will be the $4,000, $5,000 yearly expenses, and once that period start commencing, you need to pay that amount, right? So what my suggestion, that consent will be taken. If you are signing online contract, consent will be deemed to be that you have given the consent, whether it's free or enforceable. It will not be amount to enforceable, because you are using your device to give the consent, right? You are using your computer to give the consent. So it will not be taken that it has been enforced. You can deny, you can deny. So from the e-contract point of view, it will be always taken that it has been given the consent because device is in your control. It's showing that you have executed from your device, whether it's computer, whether it's laptop, it's a cell phone, iPad, whatever it may be, whatever device, because device number will be. So if it goes to the court and person challenge it, that person has to challenge first. He has not executed, right? Whether that belongs to any other person has executed, that can be disputed in that way. So then, so for that part, if it is high value contract, generally there is a requirement of certain further supporting document, which I think Navroj mentioned about the digital signature being generated, right? Once you do that, Aadhaar number and then digital signature is being generated, that is valid proof. So some additional features is being inbuilt now in the software and other things. So it will say that you have, like nowadays, if you are taking the e-signature, right, you have to do the video call and say that you are calling, you are taking the signature, your name is this, that. So now earlier what happened, it was not the case, and that many situation came that the person obtained actually the other signature in that name. So that's to avoid that, the government is now mandatory, whoever obtaining the class 2 or class 3 signature, that person has to call, video conferencing will be recorded, he has to show his own identity, permanent original identity, like permanent PAN number, Aadhaar number during the video recording, and that go as a evidence.
Right.
So,
and I think, to be honest, if it's about challenging the validity or of a contract based on undue influence on a particular contracting party, I think the question remains, or the question would be the same whether it is signed physically or by e-contracting, because you're questioning the competency of the contracting party, right? So I feel that the challenges are the same. It's just a matter of the evidence that you produce may be differing, but the basis is more or less the challenges are the same everywhere.
That's right.
And I'll probably just ask one last question before we wind up. Great questions. Thank you for being such an interactive audience.
Neha, we have a live question. Can I request Nishad Davis?
Sure. Yeah,
Nishad Davis, can you please unmute yourself and ask your question live? Nishad Davis?
Hi, Nishad.
Nice, you can hear me? Can you hear me? Hello, can you hear me?
Yes,
Hello?
Nishad, can you please repeat your question?
Can you hear me?
Yes, we can.
Yeah, still nice, very interesting session.
Nishad, your voice is breaking.
My call is to Mr.
Be in a stable network.
I think we are not able to hear Nishad.
We'll come back to Nishad in a moment. Ms. Dharti Shah, can you
hear me now?
Ask your question live? Ms. Dharti Shah.
Yes, sir. Yes, sir. Am I audible?
Yes, hi,
yes, please,
you are.
Hi. As Kundan sir said, if the contract is renewable automatically, then isn't it a invalid clause in the e-contract? Because before validating the contract again, then it should be asked before validation, right?
Yeah. So, Dharti, I'm see various in US, many states having laws about how that contract can be automated, right? It can be renewed. So there is a clause. If that provision is in that in the agreement, and they send the reminder before auto renewal starts, right? Sometimes what happened in that case, I told you what happened. That reminder came to that person, which was written in that contract, and that person ignored that reminder, and that it automatically renewed after that. So one reminder or maybe two reminders that company sends it that your contract is being renewed on such date, right? And if the tendency is that nowadays the people are getting so many emails, or sometimes it goes to your other email ID, you do not respond it, right? So that will automatically renew. So what I'm saying that if you are entering into any e-contract, and which is having whatever the terms and condition. You need to read, and once you agree, you cannot deny that later on that you have not agreed to that term, right? As far as auto
Yeah.
provision applicability itself is covered, that whether it's enforceable or not. The international laws having different states having different regulation on that. We were talking about the one state in the US where it was valid if there is a reminder given before the automatic things starts. So that reminder was given, that person ignores, right? And then it was contract valid. So there was a dispute, and ultimately we settled the dispute.
Yeah,
Yeah, exactly.
clauses are not uncommon at all. Often, I think Navroz wants to add a point. Please go ahead, Navroz.
Yeah, just a quick point to what Kundan just mentioned is that at the end of the day, what courts, and this is very common in the click wrap agreements that we sign up to on websites when we are purchasing a product or a service, and then it goes into an auto renewal mode. But what the courts have held is that the click wrap agreements have to be reasonable. They should not be onerous. So that's where the mechanism which Kundan mentioned, that there has to be a notification sent across to the subscribers stating that your subscription is coming to an end, and therefore we are going to have it renewed. If you do not wish to renew it any further, kindly terminate the contract by clicking on the link below. So that gives an option. If you do not exercise that option, then it goes into an auto renewal mode. That's what courts have held, that there has to be a reasonableness to the entire process in a click wrap agreement as well.
That's true. That's correct. Yeah.
Thank you for that. Yeah.
If auto renewal clause is there is already mentioned that there will be the notification given to the subscriber, and that notification, if you have option to terminate, if you do not terminate, it will be automatically renewed. It explains, states in that way. That's true. Correct.
Thank you, Kundan. Nishad Davis, this is last and final call in case we can hear you. Nishad Davis, please unmute yourself and ask your question live.
Can you hear me now? Can you hear me now?
No, so your voice is breaking. We're really sorry.
I'm not sure. No issues, yeah.
Your voice is breaking, so we're really sorry. Over to you, Neha. You may wrap up the session. A formal conclusion from your side before Samriddhi takes over and we move on to next session. Thank you so much.
Sure. Thank you so much, everybody, for participating. I think it was a wonderfully interactive session. And the themes that we looked at in terms of validity of the contract, essentials in a contract, stamp duty, e-signatures, a lot of questions we are, hopefully were answered. Clarity was brought. For me, at least, I think I learned a lot from this discussion. And hope we do the rapid change. And change is always difficult and it's painful. Hope we go through it and learn from each other. And that's about it. And hope everybody has a wonderful weekend.
Thank you.
Well,
thank you.
Thank you. Thank you, everyone. We thank Neha for having so flawlessly moderated the session, and to all of our panelists, Mr. Kundan, Navroz, and Sapan for joining us on a Saturday morning and sharing with us their insights. Thank you once again. Please continue to stay with us during the rest of the webinar as participants. And we're now going to move on to our next segment, which is a focused presentation on India's road to digital tax. For those of you who have just now joined us, I'd like to let you know the basic house rules. You can ask your questions during the session and after the session by posting in your questions in the question and answer box. And you can also use the raise hand icon at the end of the session to ask live questions. And I'm now going to introduce you to our next speaker. That's Mr. Vassan MS, a Senior Vice President, Global Taxation at HGS. And this is a focused presentation on India's road to digital tax. Mr. Vassan is a tax professional with expertise in international taxation and transfer pricing in particular, apart from other taxation areas. He has hands-on work experience in the field of taxation, legal and commercial functions, and has worked in manufacturing as well as service industry, such as textiles and engineering, chemicals, life sciences, pharma, power, automobiles, and IT and ITES. He has also authored books on transfer pricing, audit practices, direct taxes, Ready Reckoner, and Master Guide to Income Tax, which were published by LexisNexis India. Mr. Vasan has argued tax litigation matters before tax court successfully in India, and has negotiated with state VAT authorities, income tax, IRS for corporate tax matters, cross-border dispute resolution under international taxation, and transfer pricing audit defending the tax position. So with that, I'm going to hand it over to Mr. Vasan, who will now start his presentation. Thank you.
Yeah, good afternoon, everyone. Thank you, Neha, for this introduction. India's road to digital tax is still an unfinished agenda. Once you go through the presentation along with me, you will also feel so. Let us take a very simple example. A lot of users in India do data search as users in the platform, as well as the users who are the advertisers in the platform. And a lot of information go into the platforms of Amazon's and Google's, Facebook's. And there is a lot of data mining also happening because of the user participation. However, the analytics of the data take place offshore in other jurisdictions. And the derivatives of those analytics is received in the form of advertisement revenues and parked in the home country. So the challenge of digital tax is the data is sourced in a country where the user is there and user participation is there. However, the revenues are parked in the home country or elsewhere. So the whole complexity is, how will you track this? And how will you be able to tax a portion of that revenue which is sourced or accrued in a source country? So the whole point of digital tax and its complexity is how to tax those revenues which are accruing in a source country, whereas parked outside, and how much of that should be accrued in source country vis-a-vis a resident or a home country. So that is why this topic is very complex, very apt for this summit with information technology and legal being part of this. So if we look at the data, it is available free of cost. It is monetized across jurisdictions, which is not within the purview of Indian tax authorities to tax, because it is done outside of India. So tax authority cannot say this is augmenting revenue. What is augmenting revenue is also parked offshore. So given that the tax authorities, not only India, across the globe have a challenge. And that's why digital tax is very complex. Even the advertisers who are advertising in the platform do get a minuscule share of the profits which are accruing to the platform owners. So the value contribution by the network owners is by networking, and by linking the users into their multi-sided platform. See, if you say e-commerce intermediaries, it's Amazon. If it's a platform operator, it is Uber or Airbnb. Social networking services, it is Facebook and Twitter. Search engines, Google's. Music platforms, YouTube's and Apple. So all this user data is traded, picked up from the marketplace itself. Because of this shift from a source-based revenue taxation to a resident-based taxation, there is a base erosion in the source country, whereas the revenues are parked offshore. So because of that, even though the user is there, the contribution of the user is predominant, the base is getting eroded here because the sales is booked elsewhere. So if you look at the user participation and data monetization under the Web 2.0, it is all accruing to the network owners, who are Google's, Facebook's, and Amazon's. Whereas an alternate can come up in the form of blockchain technology, where a decentralized distributed ledger technology can be in place, where each and every transaction can be shared, distributed, and replicated to the users across, including the owners of the platform. So this could be a next level of technology which can come in place, where there could be some sort of benefit which accrue to the users also, which would be a fair point. So let us go to the first slide of my presentation. This tax is on the digital economy. Digital economy, we can call it web economy or internet economy, whatever we call it. The revenues flow from online advertisements predominantly. Of course, there are IP revenues, rental of these spaces, which is advertisement once again, is also there. So what all it involves people, business, process, and data. The whole thing revolve around which country can tax and how much they can tax. So can we move on to the next slide, please? Yeah. So let us quickly run through the journey from 2013. Of course, why I said 2013 is that is where the base erosion and profit shifting has gone so much into the countries, 120 countries and all, and where the OECD, which is the Organization for Economic Cooperation and Development, started looking at digital taxation, addressing the digital economy challenges, and to tax a fair amount for each of the countries where from the revenues are sourced. So as you know, there are two sets of taxation. One is a source-based taxation, another one is a residence-based taxation. US follow residence-based taxation, whereas other developing countries do follow source-based taxation. India particularly follows source-based taxation as well. So when in 2012 or 13, they started discussing about this, taxing this digital economy, which is very complex and which is borderless and which cannot be pinpointed to a particular jurisdiction for the revenues and profits accrued. Cost, of course, nobody bothers. So cost can lie in any jurisdiction, but that doesn't earn any revenue to the government. So when you look at the journey of this digital tax, OECD started deliberation, and sometime in October 2015, they came up with uh, a paper where clearly they said there are three ways of taxing these digital transactions. One is by way of a withholding tax on those transaction values, or by way of an indirect tax levy in like excise or VAT or GST, we call it in India. Or the third is an equalization levy. So what India did is it picked up the equalization levy and then started implementing from 2016. What it said is there will be a levy of 6% on the non-resident advertisement revenue transactions, and it will be taken as if it is a withholding of 6% and remitting to the government. The only catch the India did is the equalization levy is not part of the Income Tax Act. It is enacted as a separate act so that it doesn't get into a double taxation treaty agreements and disputes therein for a cross-border, because it's a non-resident revenue on which I'm withholding. Naturally, the non-resident will be eligible for a tax credit in his jurisdiction, which India did not want to give. So it is like a cost. So ultimately, Google will not pay, or Facebook will not pay that. It is only the Indian user who's going to bear this 6%. It will be grossed up, as we all know how the business is being run. So coming back to this journey, 2017, many of the countries, almost 90 plus countries, started taxing unilaterally these transactions on its own, because no finality has come up after meeting of 92 countries, to be very precise, in 2016. There was no conclusion made, because few countries are resident based, few countries are source based. So that is why the challenge is. So under the domestic law, many of the countries started taxing these digital transactions by way of a digital services tax or by way of a diverted profits tax. Like UK did a diverted profits tax, Australia did a diverted profits tax, because their neighboring country, Ireland, was doing all these transactions at a very low tax, whereas UK is taxed at a higher rate. So whatever profits are diverted to Ireland instead of being parked in UK because of this digital movement of goods and services, they were wanting to tax that also. So that is called diverted profits tax. So, and equalization levy, of course, India has brought in that. So the journey was going on, unilaterally taxing, and all the countries joined. In fact, Israel, Vietnam, Taiwan, Thailand, Indonesia, African countries, Latin countries, all these have started doing that. And even US did that for EU transactions. In fact, they made an amendment in the double taxation treaty also by way of an excise tax for foreign insurance companies who are earning commission by selling insurance policies in the US. So then this was going on and all the countries started doing unilaterally. So then the purpose of having a balanced approach for a resident-based taxation vis-a-vis a source-based taxation was a challenge for OECD as well as the UN model. UN model is another convention, like an organization which US follow. OECD is followed by European Union countries. And India is, of course, neither here nor there, as always we used to be. We have our own legislations and we pick up from here and there and then see what best is there for the country to make more tax revenues. There is an unified approach which was brought in 2019 and a discussion took place. And sometime in 2020, they started advocating this unified approach. Of course, US backed out from this unified approach because it was not very comfortable for them being a residence-based taxation, and most of the multinationals who are having platforms is all in the US. So they came up with the pillar 1, which is a profit allocation and taxing rights for market jurisdiction. Actually, this is where the India's role in the OECD's digital tax came up, and India was emphasizing on significant economic presence to be in place, which I will just come in a while in the next slide about the India's road to digital tax. However, India was presenting its consumption, which is predominantly there, which is almost 1/3 of the total population of the world, given that the market jurisdiction should be given more emphasis in taxing rights rather than the guys who are owning the platform. So this is where actually they came up, and the model was like the amount A, which is a deemed individual residual profits out of that MNC. MNC is making a profit of say 6%. Out of that 6%, 2% should be shared with the source-based countries. Is what is the first option, which will be based on a formulary approach for the digital as well as other areas. Can you go back to the previous slide, please? Yeah, and then we have this amount B, which is option B, is a fixed amount to be paid for those revenues which are accruing in the countries based on the distribution and marketing arrangement in that source country. The third is any excessive marketing and distribution, like for example, more than 500 users, more than 1,000 users, or 1 million users, more than 1 million users. So when there is something exceeding the threshold limit, then that should be based on the transfer pricing rules, which will be in place in that country. And the profits have to be moved from the resident base to a source base. The second pillar is once again base erosion payments. So these base erosion payments are basically, I set up a foreign branch, I set up a controlled foreign corporations where they are outside, where there is the tax is very minimal, and I go and park all these revenues there instead of giving it to the source country where the revenues ought to be taxed. So I park there and I have a tax arbitrage in that. So those are called base erosive, tax-based erosive nature. So the difference between the minimum, the tax which is, or zero tax which is paid in those jurisdictions vis-a-vis a minimum tax of say 15 or 20%, the differential should be taxed by way of either by way of withholding tax or by way of disallowing the expenses, disallowing the payments. Expenses means the payments which are made from that country to the source country to the jurisdiction where it is the foreign branch or a CFC is placed, or by way of a withholding tax, or by way of a differential payment which need to be recovered as a minimum threshold. So minimum, if it is 20%, then if it is 5%, then the difference between 5 and 20 will be recovered. Can we move on to the next slide, please? Next slide, please. Yeah, thank you. So as the topic is India's road to digital tax, so I thought I will run through this journey of India taxing these digital transactions, the e-commerce transactions. 2016, India introduced the equalization levy as a separate chapter under the direct taxes, not as part of income tax. They did so because they did not want the non-resident to take foreign tax credit. So it was in the form of a withholding nature, where a 6% of the transaction or consideration paid to the non-resident will be collected. It is more for specified transactions like online advertisements and online payments, digital payments through the gateway. And then being successful in the equalization levy and collection of monies from non-residents or from the resident on behalf of the non-resident by grossing up, India started advocating significant economic presence. The significant economic presence is a very important concept in the digital taxation. So you may have a platform, you may have a technology, you may have wonderful things digitally, but there should be consumers to consume that and make use of it and augment revenue for you by using that. So this economic presence, as our Prime Minister used to say, I have 125 crores of people, and that's the wealth in the digital era. So given that this significant economic presence has gotten to the digital tax challenges and brought in as one of the major point of discussion for the countries having more population, like the developing countries which are more populated than the developed countries, were to be benefited by this taxation. So that is what this was brought in. Of course, this has been kept on hold. There is no threshold being announced, and there was no further discussion on that because it is very complex. How to really capture that economic presence? It would be in very small lots and quantities. So capturing that and taxing it is a challenge. So they have parked it right now. They said they will bring it at a later time when the technology and the enablers are developed and suitable for taxing even at the smallest level. So they have parked that right now. And then they expanded the scope of equalization levy. They thought this could be a good way to tax these digital transactions. So they said they will bring in to tax the e-commerce operators. So what e-commerce operator means? A non-resident who owns, operates, or manages digital or electronic facility or a platform for online sale of goods or online provision of services or both. So yeah, so then they brought in what is e-commerce supply or service. So they said online sale of goods or services by a e-commerce operator or online provision of service provided by a e-commerce operator or online sale of goods or services or both facilitated by the e-commerce. So either owning or providing or facilitating or a combination of all the three. So that means nowhere you will be having a loophole to escape from this taxation. It is a 2% tax on the value of the transaction. Of course, when you are taxed under 2%, you will not be taxed under 6%. So of course, to that extent, Indian government is fair in not taxing both ways. Can you go to the next slide, please? And effective October 1, 2020, they brought one more aspect of withholding tax at 1%. Anyhow, 2% is the tax on the e-commerce. So e-commerce operator who has to withhold if the threshold limit is more than 2 crores. Of course, the other one is the seller who's receiving an amount as consideration for sale of goods having a value exceeding 50 lakhs. So in any financial year, this will also be subject to withholding tax from the buyer at 0.1%. So this withholding is more to record those transactions and go after those people subsequently if they don't file the tax return. So that's the purpose of the withholding taxes. So I collect some tax as a tax at source, and then I record that in my website and see if the resident or non-resident is complying with the taxation by filing their sales and purchases and the profits, whatever is attributable to India. Of course, now you would have seen very recently, last week, Reserve Bank has come up with blocking your debit cards from making any gateway payments. So that would be done separately by way of gateway payment approved agencies rather than through the banks. Go to the next slide, please. Yeah, this is an interesting case study. I thought I'll spend some time on this particular activity. So this is a consumer facing business, not a digital business. But this is an electronics company based out of headquartered in Dubai, having manufacturing facilities in Italy. I think I've not captured Italy, I think, in this. Okay, nevertheless, I have facility in Dubai. I have a facility, manufacturing facility in UK, and I have a R&D center in Dubai. I have a mother warehouse in Dubai. I have online platform based in China, and I have a facility in Italy also. So why I have picked up Dubai particularly is it is a zero tax jurisdiction, and all the platform online is run through Switzerland, where the server and the technology is housed. So given this transaction, this electronics goods are into two segments. One is a normal routine electronic goods and a premium electronic goods, where you will have sensors also and the technology enabled goods. So with the two set of goods being manufactured and supplied across the globe, I thought this could be a good consumer facing business where a digital platform is used for sale and purchase of the goods. So what happens here is the order is triggered from US or from India. It goes to China, like what we call it Alibaba's platform, for example. So it goes there and gets processed and goes to the respective manufacturing facility wherever this product is classified available, and then goes to the mother warehouse also, where the products could be available as a second level, and then it gets shipped from there to the respective country where from it is sourced, according to the logistics and transportation and supply chain management, of course. So in the whole activity, if a normal electronic goods, which is applied with the switches and all, is $10, and a premium with the sensor and technology is $50, how will you share the revenues across these countries and tax it accordingly? So if you look at Dubai, it has got the license to manufacture those products. A license fee is triggered there. It has got a warehouse where the warehousing cost will also be there. It has got an R&D, which is doing a lot of innovation day in, day out, and changing the design, technology, drawing, etc., look, everything. And you have Switzerland, where all these are online, updated, and gone to the platform where China will showcase that and get all these things. Of course, there is a UK element where the European customers could also have it, and US customers also can have it from UK. So given that the marketplace, the preferences of the customers is taken into consideration and housed there, how will the profits be attributed is where the issue is today. So will Dubai have the maximum revenues because it has got a manufacturing, it has got a license, it has got a R&D, and it has got a warehouse. It has got 4 activities. Switzerland has got all the online platform, storage, retrieval, analytics, and monetization of the data to China. And China, of course, is only an intermediary, which is only recording the purchases and sales and the shipment where to happen through an artificial intelligence tool. UK has a manufacturing facility. It has got a premium product manufacturing there at high standards. However, the R&D is coming from Dubai. The technological changes or drawings design come from Switzerland. So given that for the manufacturing, whatever is the cost will be recovered, balance will all go back to Switzerland and Dubai, where Switzerland is taxed at 5% for intellectual property, and Dubai, of course, whatever residual profits go, it will go to Dubai as a zero tax. So this is where the base erosion happens, and where a fair amount of allocation is becoming very complex. And unless and until the parent company in Dubai come up and say, I am spending 10%, I am spending 20%, I am spending 30% in this jurisdiction, it is very difficult for the tax administration, either in China or in UK or in India or in US, where the consumption is happening, to be very difficult to tax that. Of course, US doesn't have a source-based taxation, so we can exclude US for this discussion on digital, on this consumer-facing business through digital mode. So this is a very interesting and a complex activity for tax administration as well, on how much to levy and what is the mode of saying this much is attributable to India. It's very difficult, and it's a challenging one. India is also fighting tooth and nail to bring as much profits as possible out of this digital transaction, saying that the consumption is happening here, the predominant activity is happening here. So given that a challenge, let us quickly go through the future of digital tax, how this could be resolved. See, today what happens, the tax is becoming a main source of revenue for the governments, because all other source of activities like oil and gas is all depleting. All other source of revenues which have been there in the past in the traditional model is all gone. So tax being there and a source for their infrastructure and development of their country, even including the advanced countries whose infrastructure is very old now. It is 100-year, 50-year, 100-year old infrastructure, and they have to redo that. So for that, they need money. Even the advanced countries, developed countries also started taxing each and every activity to garner revenue for their spending on the social development. So given that each country wants a piece of that profit, each country wants to tax for their share of the supply of goods and services. Even though the supply of goods and services happen free flow, how much to tax is each country wants the maximum out of it. Consumer search and time, which is the base of all these analytics and data mining and preferences, taste and information, and then upgradation, advancement, future innovations, everything is based on that customer search engine. Is there any payback for that? Can a blockchain technology be Web 3.0 to address that? Each and every country has unilaterally been taxing digital services tax, which is not fair. There should be a very balanced approach. Otherwise, the developed countries will have a hit, which has got all these multinationals headquartered there. Last but not the least, a transparency of the flow of goods and services across countries is in the hands of the multinational enterprises, which need to come out of their closed way of working and eroding the tax base of the developing countries, where the consumption is taking place, where from these revenues are getting generated and profits are becoming very significant, which cannot be ignored by the countries where from it is sourced. So with those words, I would end my presentation. And thank you all for a very patient hearing. And I look for questions, if any.
Thank you so much, Dr. Vasan. Attendees, if may have, in case of any questions, can you please use the raise hand icon or post your questions in the Q&A box? We'll wait for a minute, Dr. Vasan, if you have any questions, and then we'll move on to the next session. Attendees, in case of any questions, you can post them in the Q&A box, or you can use the raise hand as icon to ask your question live. Dr. Vasan, we do not have any questions as of now. We are getting questions in our emails and offline as well. So we will connect them with you as soon as possible. I thank you once again, Dr. Vasan.
Thank you. Thank you for giving this opportunity. Thank you. Bye.
Thank you once again, Mr. Vasan, for talking to all of us here. And it was indeed a very, very interesting presentation. Thank you. I'm going to request you to stay back with us for our next session, which is a panel discussion. As I had mentioned, on e-commerce, heavier cart now, and we already have all of our panelists joining us. Mr. Panduranga Acharya, Director Legal, Swiggy, is going to be moderating this session. Before we begin, the basic house rules, in case you have just joined us, you can post in your questions in the question and answer box. And this is during the session. You can easily put your questions there. You can also ask live questions at the end of every session by using the raise hand icon. And we will get back to you. In case your questions have not been answered during the webinar, we will ensure that you get the answers to all of your questions offline. So let me now introduce you to our panel for the e-commerce session. And we have as our moderator, Mr. Panduranga Acharya, Director Legal at Swiggy. He's a legal professional with over 15 years of experience with online marketplace, information technology services, real estate, telecom, retail, and services industry. Over the years, he has specialized in contracts, in litigation, IP, corporate, and compliance. And prior to Swiggy, he has worked with companies such as Flipkart, with Vodafone, and Swiggy. We also have with us this afternoon Mr. Anubhav Kapoor, Group Vice President Legal and Group CS at Cummins India. Welcome, Mr. Kapoor. He is the Cummins India Group Vice President and Group Company Secretary and is based out of Pune. And as the Chief of Legal, Anubhav is responsible for legal, IP, regulatory compliance, and corporate governance practices and policies for all the entities and JV of Cummins in India. Anubhav has over 25 years of experience as an in-house counsel, which spans across various industries, including IT, automotive, aerospace, pharmaceuticals, food, banking, and insurance, and softwares and engineering. Then we have with us Abhishek Malhotra, founding partner at TMT Law Practice. And Abhishek comes with over 2 decades of experience in the legal realm and is member of both the state bars of California, USA, and Delhi. And his primary areas of expertise are intellectual property, dispute resolution, and technology, media, telecommunication industries. And he has advised clients in minimizing legal risks and devising strategies for safeguarding against criminal and civil liability. His focus remains on the TMT sector, but with recent interest, Mr. Malhotra now also advises his clients in the areas of corporate practice, including corporate and commercial litigation. And we also have for this session Sneha Jain, who is partner with Sai Krishna and Associates, and Sneha provides litigation, dispute resolution, and general advisory services to social media companies, OTT players, e-commerce companies, broadcasters, publishers, online gamers, sporting bodies, to name just a few, and has particular expertise, in fact, in cross-border IP violations, in multi-jurisdictional arbitrations, information technology, intermediary liability, online piracy, and related techno-legal issues, consumer protection laws, and IP-related antitrust issues. And Sneha has also played a central role in landmark cases, many of which have resulted in establishing jurisprudence on the subject, particularly in the field of information technology and intermediary liability. She led the team which represented Amazon in the tussle between e-commerce players and direct selling entities. So that is our panel for this afternoon session on e-commerce. And just to remind our participants to keep posting their questions in the question and answer box. And you can also ask your questions live at the end using the raise hand icon. So with that, I'm going to hand it over to Mr. Acharya, who is a session moderator, and all of our other panelists to kindly come in online, just put on their videos and start the session now. Thank you.
Thank you, Samriddhi. I welcome all the guests who have participants and guests to this panel. Good morning to everyone, good afternoon to everyone, and good evening to whoever watching from elsewhere from the different geography. And as you all know, on this session, we would be discussing mostly on the e-commerce, whether or not it's a heavier cart. And the info is already made available to you. And before I move to the panelists to ask these topics one by one, I would want to give you a snapshot of what is the growth of e-commerce in India and what contributed to the growth and where is it stand today. India is the second largest internet user country in the world. So as per the TRAI report, we have 54% of population using the internet. And now this looks like a little contradictory because the 54.4% of population using internet, and we still the second largest internet user in the world, itself is significant in numbers, and also shows up to an opportunity that e-commerce growth has in India. But obviously, yes, this 4G technology has really helped in adoption of internet users. And today's e-commerce is the fastest growing industry in India because of that. There is a huge market for expanding e-commerce in India, and that is because of government policies and also the initiatives by the e-commerce companies. So e-commerce companies has introduced cash on delivery, which significantly helped Indian consumer to trust e-commerce and start using e-commerce. And then multiple payment option, use of transacting online has been very helpful. And at the same time, faster delivery, same day delivery, these are the options that kept the Indian consumer glued to e-commerce and to come on to e-commerce very often. Right? Better services, better consumer services, replacement guarantee, refund options. These are all significant initiatives by the e-commerce companies. And now, apart from consumer goods, you have grocery, you have food, restaurant food services, you have movie ticket, pharmacy, grocery, online education, everything moving online, including your errand services, transportation, courier, everything moving online, one or the other form. Right? The future opportunity is immense because I think there are few important aspects which is also overwhelming for e-commerce. I'm not specifically mentioning this only help e-commerce, but definitely helps in consumer experience and also expanding the e-commerce in India. One being the drone delivery. The drone delivery opportunity is great. I think recently the Times of India has successfully delivered newspaper to a couple of users. And we can imagine there will be a day where drones will be delivering consumer products to the consumer's place. And then e-commerce companies are constantly innovating because of the consumer behavior on the platform, the need for consumers. They can understand very well the consumers, and therefore they can actually work on customizing the product to consumers. This means this great opportunity for these commerce companies to also roll out their own private brands to make sure they have a better priced, better product, which is made available to the consumers on their platform. And the logistics is a going to be the next big success story in India, considering the kind of business this logistic is seeing and the increase in the logistic requirement. This is a great source of raising capitals in the future. And last but not least, the augmented reality. Augmented reality helping consumers to understand, for easy solutioning of their product, issues with consumers. Most of these companies already have involved chatbots to solve the consumer problem. I think there is a tendency of consumers not really keen on getting themselves on a call and speak to someone and figure out what's the status of the product being delivered or not, or is there any consumer issues. They're like chat friendly, and therefore these chatbots could really be helpful. And I think it increasingly reducing the human effort in solving consumer issues in the recent past. So now coming to the market size, the Indian in the market size in the Indian retail as an overall market, e-commerce was 4.7% in 2019. It looks so insignificant compared to the total market size, but it is expected to reach 10.7% by 2024. This in 5 years, if you could see at 100% growth, it gonna grow, and it gonna grow massively. And currently, and also this will also, because of the adoption of consumers, the e-commerce platforms gonna be significantly increasing over a period of time. As per 2018 report, it is 120 million consumers who are shopping online, and it's gonna reach 220 million by 2025. I mean, that's also a significant number. I'm just giving you all these numbers to ponder upon on the growth of this projected growth of this e-commerce and market value of e-commerce. As on 2018 report, it was 50 billion, and there are multiple reports of speculating the growth on multiple analyses, which I can quote 3 reports, which is Statista report, which says that USD $200 billion by 2027. Goldman Sachs is hopeful that this industry will grow by 99 billion market value size in 2024. Indian Brand Equity Foundation report also mentions about 84 billion by 2024. A little aggressive, but these are the various numbers that I'm just throwing up so that there is multiple speculations on the growth, but all of them in the right direction as to how things can grow when it comes to e-commerce industry is concerned. So before I would like to move to the panelists, ask these questions, which I've listed it down. And before I ask the question, I would like to give one disclaimer. The views shared here on this for the in-house counsels are their own and not of that of company. And that's it for the disclaimer, and we can go to the questions and answers. Welcome to you all panelists, Abhinav, Abhishek, and Sneha. Good afternoon.
Good afternoon, Pandu.
Good afternoon to you too, and good afternoon to all the people who've joined in this webinar.
Great.
Hi, everyone.
So I would like to ask this question to Sneha first. So let's go with ladies first. E-commerce policy and impact assessment is the first topic. In conjunction with the Press Note 2008, what do you think? There was to the Press Note 2003 in 2014 and subsequently Press Note 2018. There were some inconsistencies while there was a greater emphasis on recognition of these e-commerce companies, and then what is inventory based, what is not inventory based, how you do the business. Do you think it is a step towards the new regime of governance of e-commerce in India?
Yes. So Pandu, I do agree that having the press note did give some clarity in terms of what the roadmap has to be. for e-commerce companies which have FDI investments to kind of understand. Obviously, the press notes apply only to e-commerce companies which have FDI, so they don't apply to pure domestic companies. But I think from an overall perspective, it did help in getting some clarity on what exactly are the positive obligations that an e-commerce company which follows a marketplace model has to follow to kind of make sure that there is no issues in terms of violations of the intermediary safe harbors available. So I think in that sense there has been a very a harmonious reading of the press notes with the intermediary liability and intermediary safe harbor provisions of 79, which have provided clarity in some form about what exactly are the due diligence compliances that a particular intermediary is supposed to follow to make sure that they don't get embroiled in allegations of misusing their intermediary status. So to that extent, there is that I understand the earlier press notes and the later press notes. There have been some issues in terms of whether the subsequent press note was a clarification, does it apply retrospectively, all those issues are there. But I think now 2 years have gone by, those issues have been sorted. The industry is now majorly looking forward to what has to be future compliances. So all the earlier issues of whether inventory based model, marketplace based model, how does that work, have at least got some clarity is what I feel.
Great. So since you have made an interesting connection with Section 79 and the intermediary guidelines rules. So these intermediaries are required to make rules under the Rule 3.
Correct.
And then be neutral about it.
Correct.
The press note 2 also emphasizes on not influencing the sale price.
Correct.
Being neutral to their sellers. There should be a parity maintained. See, there will be different cohort of sellers. There will be a different cohort of consumers. Like plain vanilla case, it looked like so, but it is not actually. It's going to be very detrimental, in my view, if the companies were to strictly follow what is required, right? I mean, this is something which I felt government have to think through and then make this evolve by itself, right? Consumers should drive those evolution for e-commerce. Who are the reason for actually a presence of e-commerce in India? So what is your take on it?
No, I do agree with you that ultimately it's the consumer demand which decides disruptive technologies and how they evolve in the business environment. And I've always been a proponent, whether it's been in the intermediary industry, whether it's been all the other industries that I function in, whether it's telecom, whether it's media, government intervention has to be soft touch intervention just to ensure basic compliances so that consumers are not taken for a ride. Their purpose should be to make sure that consumers actually benefit, businesses benefit, level playing field is maintained. But any kind of regulatory compliances which are going beyond the scope of making sure that there are consumers benefit, I think maybe I do agree that that may be problematic. So, for example, one thing you said about influencing prices. Now, that's something I think, and this is one of the major points on which every brand owner or every competitor is litigating today in court. We have at least 5 to 7 matters pending in the court where brand owners are alleging that e-commerce companies complaints have been filed in the Competition Commission alleging that intermediaries are influencing the prices. But nothing has been established. It is a model that the brand owner has. Ultimately, pricing is something that the brand owner decides. If the brand owner finds value in distributing through an e-commerce platform, the brand owner will provide whatever benefits that he can to the consumers of the e-commerce platform. So that's, I think, again, it comes back to a disruptive technology, which is, leading to changes in the manner in which business is being done. So I do agree with you that, irrespective of whether it is, or at least in the issue of influencing prices, nothing has been conclusively established, and it may be very difficult to establish considering it is the brand owners who ultimately decide the price at which their products are going to be sold in the market.
Great, great. Thank you so much, Neha. I think it's so helpful. I think this also taking me to the next question of we have Competition Commission on the one hand, we have the press notes, the DPIIT is coming up with press notes on the other hand. The third one is the Consumer Protection Act. Under the Consumer Protection Act, we have e-commerce rules, which was released this year, 2020, enacted and made applicable to companies. So would like to understand more on the applications and impact with respect to entities and then compliances. And now I would like to call upon Abhishek Malhotra and Anubhav Kapoor both. I think we will have the understanding of both sides of the world. Do you think this will increase the compliance, and this would be conducive to the ecosystem or not? Is something could you please elaborate, Abhinav and Anubhav, one after the other, please?
Yeah, so I perhaps it will be easier for address the aspects intended to be, or whether it increases compliance. In terms of whether or not it is conducive to the sector, perhaps Anubhav is in a better position to answer that. I'll try and supplement it wherever possible. But I think to begin with, the whole purpose to my mind, and once you read the e-commerce rules under the Protection Act, once it clearly stands out through this is greater amount of regulation. I think in a situation where in any sort of sector or any business, we are starting off in a free marketplace, in a laissez-faire economy, where I think the government is making attempts to try and come to terms with how a new concept works. And here I'm of course, we are today not calling e-commerce new, but when it did come about and when it did start proliferating, I think there was a time when the government and the consumers were not were still waking up to how to react to certain aspects of this particular type of marketplace, or this way of purchase of goods and services. Over a period of time, there has been a lot of hankering by various stakeholders, some sort of how exactly it is that an e-commerce platform or a marketplace can actually be run, and what would possibly be the limitations in terms of which that they would apply to them. That a business no roadmap to either itself, and therefore it's always saying we do not know what this particular decision may lead to. And at the same time, that there is also chaos that results from not having any specific regulations applied to a new type of activity in terms of what exactly do you set out as a for either air their grievances, try and take action in this. Juxtaposed with that is the long-standing and, to my mind, often misunderstood, and to a certain extent, therefore, expanding contours of what exactly is an intermediary. How do people treat intermediaries? How do the courts treat intermediaries? And how does the legislature treat the intermediaries? So you start off with the proposition that the intermediaries are supposed to be only the pipe. They are only facilitating the transaction. And for lack of a better word, their control over the kind of activity that goes on that platform is in that sense even lesser or much related to a brick and mortar world, where the interface for the consumer is happening at the local shop, at the retail outlet. So it starts with that. But by the by, the development of technology takes us to a situation where there are technological measures, I'm not talking about human interference, technological measures that can be put into place to at least address some of these aspects and some of the concerns that are voiced from time to time. Then you have a movement which goes towards where there is greater amount of not only control exercised by the intermediaries, but the intermediaries also find it conducive to add to the platform perhaps their own white label goods, or maybe move away from the marketplace model to the inventory model. So I think the development of the business has been such that it may have required a response. Now, whether or not the e-commerce rules are an appropriate response to that, I don't think we should be so quick to judge, because any such regulation, any such stipulation, any such law takes a little time for it to actually play out in practice. Unless it is interpreted by the courts and the regulation and the regulatory authorities, we will really not know whether this has worked or not. But without going into those aspects of what it is likely to finally evolve as, just 2 or 3 points before I hand over the floor to Anubhav. The first aspect is that we have and of course this is a reflection of the reality and how the business works, but we have a long arm statute being exercised through these rules, whereby application extends not only to Indian businesses but also those foreign entities that are engaging in e-commerce activity. And there is a requirement. It's not only limited to just a generic statement that foreign entities will be within the scope of this. They also must provide a nodal officer in India to who can then be raise grievances to, etc. So that's, to my mind, a very bold step, and very often what used to happen, because we litigate in courts, and one of the arguments that we often were to take on behalf of such platforms is that, look, we do not really have a presence in India. Can courts in India really exercise long arm jurisdiction, specifically in the absence of a statutory provision? Now, only in Congress can the rules actually provide for a long arm jurisdiction, which may or may not be clearly readable from the statute. That's the first aspect. The second aspect is, to my mind, the concept of a Consumer Protection Act is for the protection of the consumer, as the terminology itself suggests. With these rules, being in the concept of a user who can access and avail the computer systems of an e-commerce provider. Now, what is the purpose of trying to provide it, and whether we are extending the contours then protection requirement to a consumer's self-employment commercial requirement, to then also allowing information rights to certain users who may be pure business entities. So how is this expanding, whether the scope is going in the particular direction which was not really intended by the act as it was originally envisaged? The of course, duties are numerous and multiple that have been set out. Very interestingly, the rules themselves specifically provide that these rules are in addition to the legal metrology packaged commodities amendment rules of 2017, and they also have the application of the NDI rules, which is the foreign exchange non-debt instruments rule, because those are specific stipulations that apply. And of course, this is in addition to the IT Act and the IT rules and the intermediary guideline 2011. There is also a DPIT internal trade draft policy that is being considered as a backdrop or a fallback position, which could be further enhancing it. So I know I perhaps have spoken a lot and brought in put in a lot of issues that are likely to be thrown up for resolution by courts. But over to you, Anubhav, as to what you feel is possibly the likely impact of this from a company's point of view.
Thank you, Abhishek, for a nice segue, because I think you touched upon some of the core issues that were the first reactions as we saw the rules rolled out in July. So you are right. I think there is always, when these kind of progressive rules get launched, there are both sides of the coin, right? So I think the good part about what we were very happy about is that at least this was a very progressive law. The Consumer Protection of 1986 moved far ahead in terms of recognizing the new digital economy that India is gearing up to. And also it had kind of addressed some of the issues which were erstwhile not addressed in the earlier act. So I think the needle moved quite ahead, which in some of the areas we have been long waiting for. Say, for example, under the data protection, it's already been like 4 years. We have been debating and debating. We still don't have a act in place, which we can call our own specific data protection act. But at least now, I think this is a very positive step that we see in terms of the legislation coming out. And also the government was quick enough to address it through the e-commerce rules. So I think from that point of view, this I think is a very welcome step in the right direction. But in terms of the questions Pandurang asked us in terms of whether it has increased the compliance burden, and second in terms of are there more complexities on the companies who are into e-commerce? I would partly agree to both the positions that yes, the plain reading of the act looks like that the act kind of merged many of the other acts that were already applicable, right? It even touches many of the existing acts, and it kind of dovetails into these rules. And so to that extent, I think it creates the compliance environment for the e-commerce companies, makes it more complex. And as you already touched upon, like there are 6 or 7 other legislations which are directly impacting the e-commerce operations, like the legal metrology or NDI guidelines, or even the government is now working on a new e-commerce policy, which kind of will give more direction. In the past, I think it was more controversial. So I think from that point of view, it does create an environment which is more complex for the e-commerce companies. I also bit feel that I think, and that's the difficulty of writing a legislation in the IT space also, that they've tried to classify the entities into marketplace entities or inventory entities. This is in an IT world. These are not sustaining definitions, right? Because the way technology progresses and the fungibility of the organizations in terms of the services they can provide, I think those kind of categorization, I feel may not stand the test of time, given the pace at which the digital economy may move, or even the entities won't be in one silo. They may move from one side to the other, or a inventory base may provide other services as well, right? And also we are dealing with multi-channel scenario here on the ground, right? There are companies who use multi-channels, including e-commerce, to distribute their products and services. I think if we try to kind of through the rules or the act try to straitjacket some of these, it may not be sustaining, right? It may give rise to more complex interpretations and litigations in the future. But overall, I feel given it is early days, and as any act kind of a new piece of legislation rules out, there are gray areas, there are more explanations to be given, there are more clarifications that will come out. I think this is a very positive step in the right direction to regulate the e-commerce companies. Though there are areas which will require more clarifications and it will impose more compliance burdens on the company. But overall, I think it is going to regulate this space and bring more discipline and sense into this marketplace. So I'm more positive rather than negative in this.
Great. I think I take away, like, we need to see how these rules play out. We need to give time, number one. Number two, whether there will be a compliance burden onto the companies. There will be, I think that should be all right. And thirdly, I think it is all the way more important because consumer protection is more important, right? So there is other point of views, whereas whether government is intervening into like how one should be doing business and why only specifically target e-commerce companies. Right, I don't see similar requirements for the offline sellers. You can read the e-commerce rules. The liabilities for the online sellers are so stringent, as if like obligations are like very, very stringent, and I don't see similar obligations on the offline sellers. Like you also mentioned, there are sellers who can be selling online, they'll be selling offline, not only through their own channel. There are multiple channels of sales. They could have a distribution channel, they could have a direct selling channel, right? I would come to the direct selling a bit later. That's another conflict. But I would like to take a step back and ask Anubhav, from the Consumer Protection Act, the parent act for these rules. What do you think, like, what it does not cover? Like it already covers, mostly the product liability, and there is administrative reform, and then the empowered consumers, the place of filing complaints. All this has been already solved. I think you have already empowered the consumers enough. Why there was a need of e-commerce is something that could be an interesting point to be discussed. I would like to hear from you on what this consumer protection has, which e-commerce rule had to cover, right? So over to you, Anubhav.
Pandurang, that's a very interesting question that you pose, right? And let me reflect in terms of what were the frustrations in from a consumer point of view, right? When dealing with e-commerce channels, let us just reflect, put ourselves on the consumer side, right? And some of them, I would say, is number one is the payment channels, right? There were so many frauds happening on the payment channels, and there were no redressals. We know how the cyber cells in the country are equipped, right? I think there are some nodal cells which are very active, but this service is not available in the smaller towns of the country. It is still to be developed, right? And that whole infrastructure of enforcement, if you go with kind of fraud situations, it's terrible. And there were many instances on some of the e-commerce sites which there was no answer, to the extent that I heard some stories that the fraudster was blatant enough to call back the person whom he has defrauded and calling him, do what you want, I'll see what you can do, right? So it is to that level of which I thought the consumers, it was shaking their faith, right? It was very difficult for us to move to a digital economy through electronic channels, but incidents like this were shaking the faith in the consumer itself, right? And the adoption of these digital payment channels was by force. The whole demonetization regime that we went through, it was suddenly by force that we had to just adopt these digital channels. And when the things were getting normal and these kind of incidents were happening which we could not address properly, I think it was shaking the faith. I think to that extent, I think the e-commerce rules, by putting the disclosure in terms of what payment channels are to be done, what charges are there in terms of breakup, disclosing the refund policies, I think they were not covered under the normal Consumer Protection Act, which e-commerce kind of now imposes a very, very clear description of them, and not only the description, but in terms of what will happen in terms of if it is not done. The second issue, I think the trend I would see from a consumer point of view is this entire patriotic policies that have been that have been doing the rounds, right? I think it's a very common faith or discussion in the civil society that if you buy goods from your national companies, it is going to be adding to the gross domestic product of your company, right? And I'm talking purely not from a lawyer perspective now. I'm from a consumer side, right? How do I see things? So I think with all the countries now saying the same thing and coming out with policies which are more patriotic, I think things like declaring the country of origin and things like that, which were unheard of before, right? It were there in custom laws. The BOE always used to have the stamp, right? But now having that on every product is extremely interesting for the consumers, right? Because now they can make a more decisive choice which goes beyond the price and the content of the product they are buying, to kind of a level where they can make a decision in terms of, do I buy a product from China, or I can pay 2 rupees more and buy a product from the India market, right? So I think that kind of choice was not covered in the legislations before, which now I think the e-commerce rules really kind of empower us. From a grievance redressal, I think it was such a frustrating experience when you call these companies, because the more you call, you will be lost in press 1, press 2, press 3. And especially when it comes to the elderly, I think they can't even handle technology, right? Now with all the grievance rules that are being put in place, where you are required to appoint an officer, you are required to acknowledge the complaint within 48 hours, redress it. I think it has posed much more clarity in terms of how these companies will have to be addressed, and the common notions that these companies are generally operating from foreign countries and the law cannot reach them. I think those are the things that brought a lot of clarity through the rules, right? I think now as lawyers, if we have to advise, I think we can be much more clear, and also the e-commerce entities have to be extremely clear in terms of the compliance in meeting those requirements. So I think overall, I think while it appears that it is a little more over-regulated, and it in some areas gets into which is basically the private domain of how a person does business. But as I said, these are early days, right? It is very difficult to kind of make a comment whether this is the right level of legislation or not. I think time will tell as the things move into operation, and we get little more clarity on that.
Yeah, that's an interesting perspective, Anubhav. I think that is taking me for another question for you on the compliance. And before I were to come back to you with that question, I would like to hear from Abhishek. What has really changed from the erstwhile CPA to the current CPA? Like how it is so overwhelming for consumer protection, right? So this is something
Was talking, Pandu, there was some issue with regard to my network. Is it resolved now?
it is better now.
Am I odd? Okay, all right, great, perfect. So, couple of things before I am able to answer the question that you just posed to me. I'm just trying to take a slightly contrary perspective from what Anubhav advanced, because that's the basis of a lively discussion. What if we were actually to not have had these rules? And instead, what if the definition of in the act itself would have included e-commerce entities? Would it have been any different? Would the act have been able to achieve the objective that these rules seek to achieve, even in terms of whatever is set out therein? To my mind, it would have been possible, maybe with a little more clarity through the regulator that's been set up under the act now. And I say so because of the fact that once you include these entities, the e-commerce entities, within the scope and definition of entities that can be proceeded proceeded against under this act, then the only aspect that remains is whether or not there was deficiency in service, whether or not there was unfair trade practice. And that, to my mind, is the domain of the courts to decide whether in that particular given situation, this amounts to the deficiency in service or it does not. The second aspect, and I'm trying to bring in an answer to the question that you just posed to me, Pandu, by by making this sort of contrary view with regard to the rules. What are the other changes in the Act that could perhaps have helped us not go through another detailed documentation and seek to interpret that and get into the entire argument of whether or not this is conducive and consistent with the Act, or whether or not it increases the scope, etc. The other thing is there is a CCPA that is being set up, a Consumer Protection Authority. They are charged with the functionality of actually with the overall umbrella obligation of bringing about greater amount of consumer protection. They are charged with the functionality of coming out with regulations and of suggestions as to how the administration of justice in this particular aspect can be better achieved. The authority, like we have other regulatory authorities, could then have engaged in an open consultative process whereby you invite the comments of the civil society, of the stakeholders, and then come out with a nuanced set of regulations that apply to and cater to both aspects. It is the Consumer Protection Act, but what has to be seen and the lens through which it has to be seen is there are stakeholders both as a consumer as well as the service and the product provider and the marketplace that is selling it. Unless you have some bits of the Act and the regulations that are actually catering to genuine and reasonable issues arising out of both ends, you can't have a comprehensive legislation that addresses the concerns of the entire ecosystem, to my mind. So the CCPA then gets into the Act. It provides that. The CCPA did not exist under the earlier Act. That's a new addition, and that's a welcome addition to the entire ecosystem infrastructure. Now, the point is that in terms of as access to dispute resolution or access to your grievance redressal, there is a possibility of the complainant filing this claim in the place where the complainant works or resides. It earlier had to be filed in the defendant's jurisdiction. So that's a welcome move. The second aspect is you can now actually file an e-petition. Of course, with the overall development of the infrastructure, and perhaps a part of this pandemic has really ushered in the need and the requirement for moving in the e-direction. But this is an additional welcome move. The other aspect, of course, the pecuniary jurisdiction will, of course, keep increasing from time to time, given the economic condition. But the important aspect, again, of dispute resolution is that there is a clear recognition of an alternative dispute resolution mechanism through the process of mediation. Because to my mind, amount of litigation that we've done in these spheres, if there is that institutionalized mechanism of an alternative dispute resolution, I think 85 to 90% of these disputes could be resolved through that process. And we've seen that work wonders even in the formal adjudication system. So if you have a panel of experienced mediators who have that particular background in this sphere of activity, it clearly can reduce the burden on the courts, on the consumer protection specific dispute resolution mechanisms, and thereby achieve a resolution which is a win-win for both. And very importantly, and this really is a massive change in terms of recognition of product liability and extension of that liability not only to the product and the service creator, but also the person who's actually selling it. You are basically, through this process, bringing in a higher level of due diligence that needs to be exercised at the level of the person who's offering the goods or services, compared to the classical principle of caveat emptor, where the buyer must beware and the buyer must carry out their due diligence. Here, and that's a welcome move to my mind, where you are putting the onus, because of the fact that earlier there was lack of information. Today there is proliferation of information. So even there, for it to be able to be a proper, appropriate information, the message should come from the person who's creating the product or the service and or offering it. So that when there is that particular message and that information, consumer can not only take an appropriate decision, and one of the factors that Anubhav just identified, the consumer is empowered to even today decide whether they want to spend that extra 2 rupees and buy an Indian product or a German product or a Japanese product and not a product originating from China, for whatever reason it may be. and that's consumer empowerment. But also that the consumer then exercises its decision consciously on the basis of those representations made, and those representations then also now thankfully extend to endorsers. So the people who are endorsing these products or services also have to exercise their due diligence that the product or service that they are actually endorsing meets at least the minimum thresholds of the information that is being imparted. And that I think is a huge welcome change. That's it from me.
Great, great. I think it's so helpful, you know, touching upon all these points and, bringing more perspective to it. I will now want to go back to Anubhav. So Anubhav, would like to hear from you. What are the tips that you would like to provide to companies who are in the e-commerce business on the compliances? What are you doing, right, in terms of advising company on the compliances?
Thank you, Pandu, and thank you, Abhishek, for adding that extra spice to the discussion. And because I was when you were narrating the whole thing, I think you touched upon many of the aspects that now we are thinking under the compliance regimes as well, right? So uh, I think there are many of them, but I will touch on a few of them, right? Maybe 5 or 6, and let's see where we go from there. Uh, uh, the first one, I think, is the new act introduces two very important terms, which were one is product liability, and the second is product recall. Now, both of these are very large terms. I think product liability was existing in the ecosystem for quite some time, but it was never part of the and the way it has been now listed out in the Consumer Protection Act, it is something that is now getting more prominence, right? And we've seen these kind of actions in some of the Western countries where the liabilities are extremely large. If it is class actions, and you have to have product recalls by, and some of these can really put a lot of emphasis by companies who are selling products, or in terms of their quality control processes, right? And not only not I'm not saying that the existing processes are insufficient, but with this entire large liability on that comes with this act, I think, and the mechanisms that are being put in place to kind of enforce these kind of consumer activism puts more pressure on the companies or the product companies to be more quality conscious, and also to care for their consumer better, right? Not previously, I think people now, not only they are required to kind of appoint grievance officers, they are required to acknowledge their complaints but redress them within a given time frame, and there are specialized agencies to address it. I think the whole emphasis that has been now placed is on the consumer care through the legislation, which was a little dilutive in the earlier act. As this is how I feel. I think uh, moving from there, I think Abhishek touched upon this entire change in setting of these new administrative bodies, and also the ability of the complainant to file complaints from anywhere where they reside or work for gain. Previously, I think this is a huge plus, right? But what it means for companies is that now we can have complaints from anywhere in the country. If you are in an e-commerce environment, you will the places at which you can reach out is far and wide. So for a in-house counsel, you can also get complaints from all the places where you are giving your products and services, which basically means that you may now require a new kind of firms, which are like kind of network firms, which can address these complaints at all forums as well, right? address these wherever these legislative bodies are there. So I think that is one area that obviously we are reinforcing the entire council network. Also, in terms of I touched upon the quality where the extra points are being, or extra emphasis and processes are being put together to kind of reinforce the processes now, which are required under the law to address the grievance complaints. And the third, I think Abhishek touched upon the endorsements, right? I think many of the B2C brands or businesses that are there in the e-commerce environment have to be very, very careful, and especially with the celebrity endorsements, right? Given the environment that we are in India, where celebrities can pull a large amount of consumers towards them, I think now people, the companies have to be much more careful in terms of, because the liability can not only come to the company but also to the endorsers. So I think that area is another one which is going to get little tougher, and also the companies will have to back up their claims with more due diligence, more tests, so that these kind of liabilities can be averted. And that is one of the other coaching or the sensitization that we are doing with our marketing departments to, in terms of being more proactive and changing the way they present their products. Another area I think is the compliance with standards. I think a lot of emphasis now has been placed on unfair trade practices, right? It was there in the earlier Consumer Protection Act, but now I think there are very, very specific provisions regarding disclosures, regarding the entire provisions related to in terms of what are unfair trade practices, right? And in terms of bundling of contracts of products, in terms of disclosing the price, breakups, charges. I think that is one area where we are revisiting some of our manuals and booklets, where the disclosures or the languages have to be rephrased in terms of giving those additional disclosures in respect to our warranties and certificate of origins and country of origin disclosures. So that is another area I think which will be helpful if companies could revisit that and comply with the law. And lastly, I think it is also about allied laws which are applicable for e-commerce companies, like data protection. There are more stringent provisions in respect to that. There are penalties under the Consumer Protection Act if you disclose without reason the data of your consumers. So and I think lastly, for in-house companies, I think the best tool we have is awareness and scanning their internal environment, which basically is where we start, right? So right now, I think there is a lot of sensitization training that we are doing in terms of the new laws. In the process, we are touching upon some of our internal processes so that we meet the compliance standards that are required for the new piece of legislation. I think those are some of the 5-6 areas or steps that we are taking right now to meet the new compliance regime.
Anubhav, I think
one aspect, sorry, just wanted to bring in one element in term, because it's one aspect of a compliance which to my mind would have been helpful to have in the new act, and which we do not find, is the aspect of, and it ties in with the concept of product liability. In today's world, especially when we are, I mean, I'm talking pre-pandemic, when we are moving so much and people move from one place to the other and one city to the other in terms of geographical relocation. And even otherwise, there is constantly less and less space available for us even to store our own, requirements on a daily basis. That very often the document, very important document containing the warranty that accompanies a product gets misplaced. Now, if you are to enforce a claim generically under the act or specifically in relation to product liability, very often you will be asked as to where that warranty document is and where is that original invoice, etc. At least in the USA, there is a specific amendment that has been carried out where they have provided for an e-version of such warranties. So when you purchase a product or a service, you have the option of opting for an uploading of your invoice and the accompanying document onto a particular server, and you are provided a unique password from which you can access it. Now, to my mind, that's a very, very helpful consumer-centric regulation, which would have been great to have been introduced along with the product liability aspect. We've missed out on it, but this is one area clearly that the CCPA can recommend in future.
Yeah, I think it's this most of these observations that both of you made is nothing but the fair business practices one can expect from a company, right? And there is absolutely nothing new or nothing overreaching when it comes to this introduction of these rules and this act compliance requirement. I think it's more about fairness. Now it is being enforced under the CPA and the e-commerce rules, so that companies, if not following those fair business practices, fall in place to practice those. But I think there was another tussle on the same line. There is another channel of sales like direct selling entities. So I would like to take this question to Sneha. Sneha, what do you think? Is it really a tussle between direct selling entities? Why not these products be sold online, right? So there is model framework guidelines for direct selling entities, which mandates that so someone selling on the platform should have consent from those direct selling entities, whereas High Court of Delhi says absolutely no requirement. And India is a free country where when it comes to retailing, national exhaustion and international exhaustion is okay in India. I mean, in this context, what do you think? And where are we heading to?
Panu, let's step back for a moment from focusing specifically on direct selling entities, and let's just look at the proposition that these entities were actually forwarding in the public fora and also before the Delhi High Court. The proposition that they were forwarding was that no person should be allowed to sell my product without my permission. That's at the core of it. That was the proposition. And that is why that clause 7.6 was introduced in the model guidelines, saying that any person who wishes to sell on an e-commerce platforms requires my permission. Now, let's remove the direct selling entity aspect here for a moment, and let's look at the models that are available in India. Today, there is no restriction under any law in India for any retailer to require permission from the brand owner to sell the brand owner's products. It is very, very common for us to have in our corner stores shops which are selling genuine products without actually having a written permission from the brand owner that they're authorized to sell that product. That is nothing but being a reseller. That is nothing but being a retailer, which is completely protected within the scope of Article 19(1)(g), which guarantees to an individual the freedom to do business and trade in the manner that they want to do. And Indian public policy, Indian laws have also carved out in every statute a situation where once the title in the goods passes, and that is what the Sale of Goods Act provides, that is what the Trademark Act provides, that once the title in the product has passed, the brand owner cannot restrain the resale of that product except in very exceptional circumstances. For example, if somebody is actually tampering and changing the quality of that product, there is a legitimate public interest reason, consumer interest reason, which the brand owner will have to restrain the resale of that tampered product. But simply because the product is being sold outside the exclusive distribution channel of a particular brand owner does not make the product illegal, does not make the product unauthorized, does not make the product counterfeit. And I think that is what the Delhi High Court ultimately upheld, saying that you can't have, I mean, if you want to enforce your exclusive distribution agreements, there is a contractual remedy you may have, but you can't say as a principle of law that a genuine product which is in exactly the same condition in which it was manufactured, without any quality issues arising on the product itself, being restrained from resale without the permission of the brand owner. So I think from that perspective, it's not a direct selling entity specific proposition. These kind of litigations have been filed by brand owners also. They are currently pending in the Delhi High Court, where owners also have filed litigation saying that e-commerce entities should not permit third party resellers. Only authorized distributors should actually come forward and be permitted to sell on an e-commerce platform. And a burden has sought to be imposed on an e-commerce platform, saying that this is they should check before they permit sales. Now, I mean, we're talking about physical products here. Let's change the model a bit. I mean, we have so many services which are being provided in the e-commerce model. We have so many, for example, it is now I understand that when it comes to issues, if you remember, there was some time ago, there were some issues about, there was a specific different tab available in a particular e-commerce website where they had said that these products are reused products or these products are refurbished products. Now, there could be some little bit of argument available in favor of a brand owner on why refurbished products, there are certain checks and balances you may need to have permissions to sell those products. Even there, for example, so long as the products are not harmful, if they're not against consumer interest, you can go ahead. So I think it's not a direct selling entity specific provision. It's more a provision about, or a discussion or debate about to what extent can you enforce and restrict your exclusive distribution channels. I think that's the main tussle which is happening in the industry. And just to add on,
Great, Sneha.
Just to add on one small
Yeah,
point, it's not e-commerce specific. Today or tomorrow, you can have exactly the same argument against a mall owner who's permitting a shopkeeper to sell products without, I mean, the shopkeeper is buying products from 10 different sources and selling it. So I think that's the larger question always.
As a consumer, Sneha, what do you think? I mean, you should have an access to this, products manufactured by direct selling entities be available online.
See, as a consumer, I want a product at the cheapest price, to be honest. So if I'm getting the benefit of discounts where the middlemen are being removed, see, how does any distribution model works? There will be 4 distributors in the middle who will each have a cut. And if the cut is getting reduced and the benefit of a deep discount is being passed on the consumer, then why should the consumer not benefit from it? So long as, and again, I caveat this by saying, so long as the product that I'm getting is the genuine product, the company, the brand owner has earned its money. It's not like the brand owner is losing anything out because they have sold the product. It's the middlemen. And this is again, we come back to the first question you'd asked, Pandu. It's a disruptive model. Ultimately, it's a disruptive technology which has come to create havoc in the market in terms of giving the benefit to the consumers. So where do you draw the line? There will, whenever disruptive technologies come, there would always be certain people who will be unhappy about, having their business disrupted.
I think I completely agree with you. I think there should be some amount of harmonization where people have to come to the terms like, e-commerce here to stay. Whether it is brands or whether it is existing other channel of sales, right? It is e-commerce going to stay, and I think they should try and build how innovatively they can still reach to consumers. I think rather all the commerce companies to brands to the service retailers, offline retailers have to come together to eliminate the spurious product, make sure that genuine products are reaching consumers at best price. As long as consumers are benefited, I think everything should be all right. And I think courts also like moving in that direction in dealing with such matters. Like we have seen SanDisk matter involving Snapdeal, where one of the seller wanted him to be declared an authorized seller of that company. I mean, see, I think there should be some lines should be drawn as to who does what. And when it comes to a product already in the market, the brand should be little cautious about exercising their rights as far as the brand is concerned.
And this is where all the competition issues will also come in. I mean, a brand owner cannot have market segmentation in the manner that they're feeling, because ultimately it will then lead to fixation of prices. And that is ultimately not in favor of consumers, nor even in favor of competition.
Very, very important point. So I think we almost like coming to the end of the conference. Before I conclude the panel discussion, I will like to ask one last question. I think Abhishek, this is directed to you, and like you heard us, like what Sneha and I discussed about how this harmoniousness is required when it comes to selling of certain products. E-commerce is a great tool for having these brands or certain products to be supplied to the consumers. Now e-commerce is no different from that, right? And e-pharmacy is one of the important segment where the consumers are also be required to have an access to the right product, eliminate all spurious products, and have an easy access, so which will reach them quickly at a better price than it is available in the offline market. So what do you think it's between the new age business and the traditional business? Do you think it's a battle at this point in time? In view of this specific, no, in absence of clear legal regulations in India, and this recognizing the e-commerce benefits is also lacking here. So in that particular context, I would like to hear from you, like, is it a real battle?
So, no, I don't want to label it so that it is a battle. At the end of the day, when we are looking at bringing in these concepts, as I think the tone and tenor of this particular discussion has also been, it is about getting the best deal for the consumer. Now, if today there is a facilitation and a facility available for the consumer to be delivered the medicine at their doorstep, and very frankly, if it is essentially an extension of your neighborhood chemist being called from your home, and then having the facility of having that medicine delivered, what this is now, what an e-commerce version of that is doing is essentially not only allowing you to do that instead of a phone call, you're able to do that through the internet, through your device, perhaps the same device, which is your mobile phone. Rather than just making a voice call, you are placing the order through the application or through the website. Now, the other aspect which needs to be considered is that whereas that local neighborhood chemist is regulated in as much as they must have a retail license, and they also must have a registered pharmacist there, which is the requirement of the law, where it's another matter whether people follow it or not. But at least when it comes to regulation, that's the aspect that needs to be extended. And that was where the problem really was. The entire debate about people going to courts and seeking a stay on the applicability and the business of running e-pharmacies was this entire confusion being caused as to whether the applications and the obligations that apply in the brick and mortar world are sought to be short circuited through the e-commerce platform. And it is for that, therefore, that these draft regulations that have been circulated, they seek to address those. You have to essentially ensure that what the consumer is actually getting is what they have asked for, the sourcing is correct, and it's not of inferior quality. The second aspect is that the entire debate about OTC versus scheduled drugs. You do need a prescription for a scheduled drug, even in the brick and mortar world. In relation to the OTC, while it is not defined, it is usually a default proposition that whatever does not fall within the schedules is an OTC product. For that, there is no requirement of a prescription. Now, with the proliferation of technology in the healthcare domain, and with also the telemedicine guidelines being put out in the public domain and being notified in May, there is some sort of a congruity that is sought to be achieved between the delivery of overall healthcare through the digital domain and through electronic means. And added to that is the facility of providing an e-prescription, which then gets delivered directly or uploaded directly to the e-pharmacist, who then provides you with that solution. But the important aspect is, because it is consumer protection, because specifically it is in the nature of healthcare and pharmacy and pharmaceuticals, which in any case is regulated, that regulation can't be short-circuited only because you're doing it in a digital domain, is what is the important aspect. Now, the draft rules, to my mind, that are currently in circulation, to my mind, they are fairly adequate in the present scenario, because they do provide for authorization, they do provide for licensing procedures, and the applicability and the appropriate enforcement of these rules, however, to my mind, will only be, it can't be looked at in limbo or in a silo. It has to be in conjunction with the e-commerce rules. It has to be in conjunction with the Consumer Protection Act, and it has to be in conjunction with now the oft spoken about and eagerly awaited data protection legislation. So I think once all of those pieces come together, some of which have already are put in place, we will have a robust mechanism by which the consumer will really realize the felt need for effective doorstep delivery of all of these products and services. Thank you.
Great, Abhishek. I think that's a useful information that you have shared. I have a follow-up question on that. So what do you think compliance will be like very different for e-commerce companies than what is offline for the offline pharmacist? Would you like to talk about that?
Yes. So basically, the compliances that are required for the offline pharmacists, they will have to be made applicable to the e-commerce entities in any case, in terms of you having at the back end, at least, a registered pharmacist, you having the relevant licenses for the purposes of selling this. And there are going to be additional burdens, given the fact that you are having applicability of the data privacy requirements, you having the applicability of the IT Act, you having the applicability of the Consumer Protection Act, and now the e-commerce rules. So if you have to play in this particular domain, then the sector specific requirements, which is the fact that you are an e-commerce entity, will in any case be applicable. In addition to that, because you are specifically engaging in an otherwise regulated environment of healthcare and pharmaceuticals, that additional level of requirement will have to be complied with. So yes, to answer to your question is yes, there will be an additional level of that obligation that are imposed on such entities over and above what is applicable to the brick and mortar organization.
Pandu, I'd just like to add one thing to what Abhishek sir said here.
Yeah.
I mean, I have a different take here simply for the reason that I think, to my understanding, e-pharmacy, I mean, we have to keep in mind the different role of an e-pharmacy, which is possibly a neighborhood pharmacy selling online, and a marketplace model of pharmacy, which is actually not the seller here. They are just simply providing a platform for the patient to connect with a pharmacy. So I think to say that the compliances which marketplace model or a pure intermediary e-pharmacy has to follow should be either identical or in addition to what a physical pharmacy should follow, would I think possibly be conflating the roles of both. Because and this is something that I think is at the core of is always at the core of the e-commerce debate, which is the marketplace model versus the inventory model. If an intermediary, even in the e-pharmacy sector, yes, there may be slightly higher due diligences that a e-commerce entity and intermediary which is operating in the pharmacy space may have to follow, because they're dealing with regulated goods. But I don't think there should be a higher burden imposed over and above what has already been imposed upon a physical pharmacy, because physical pharmacies are sellers here. The intermediaries who are operating in the pharmacy space are not sellers, they continue to be intermediaries. So I think on that point I would just disagree and have a slightly different opinion than what Abhishek actually mentioned.
Great, Sneha. I think it's a different point of view. I think both are all right in their own way. See, what we heard from you guys is the compliances is something that is coming from a kind of a fear of understanding this e-commerce, like be it regulators, be it consumers, be it brands involved in the entire growth of this. I think there is consumers increasingly adopting these e-commerce platforms, or maybe like adopting to the transactions, which is more or less e-commerce. Some of the other form, I think most of these companies, most of the services now available on an electronic form, right? So in this context, with those additional burdens should be all right. I think e-commerce has to take this challenge now to only instill more trust onto the mind of consumers. With that note, I would ask like last question, only to take a bite from you on like short answer. E-commerce, a heavier cart now. What's your answer? Sneha.
Pandurang, consumer is the king, right? Heavy or not, but it is certainly good, positive.
Right, cool. Sneha?
Yes, I think it's definitely a heavier cart in terms of compliances. But I go with what Anubhav said. Consumer is the king. So I think disruptive technologies are here to stay. And this will become hopefully lighter in the future with light touch regulations, as opposed to being a more heavy cart for compliances and regulatory issues.
Great. Abhishek?
I think the consumer will cart the e-commerce entities along. And as we go by, perhaps we will see a greater amount of clarity in what exactly is likely to happen. So it seems to be a heavy cart right now, but I think perhaps over a period of time, and I agree there with Sneha, either it is from the point of view of a legislature's perspective or a policymaker's perspective, or it really playing out in terms of better rules and more streamlined procedures, that cart is likely to get lighter.
Great. Grace, insights.
Good point on harmonization. I think over a period of time, there will be more harmonization between the physical world and the e-world, right? And a lot of these questions we debated will iron out over a period of time.
I think there is some amount of a fear factor, Anubhav. I think everyone have to work towards like eliminating that fear factor. Now, unfortunately, the case of cyber crimes is continuously increasing. It is really not helping the digital economy or e-commerce, right? So I mean, I think the environment is not so conducive when it comes to availing these services on electronic manner. Everything will be all right when things start falling in place. Thank you so much, all of you. I think we now will move to the Q&A session. Samriddhi, you have anything to say? Yeah.
Right. No. You can take the questions now. And
Andu,
I can see, I
just
think
to
we have 5
check,
questions in the Q&A.
if we have covered all the questions in the Q&A box, Pandu, just with you.
No, I'll just check. I'll check what are the compliance companies should mindful. Yeah, I think first question is answered during the session. And there was, second one was, okay, difficult to come up with all preserved regulatory framework. Why are we shying away? I think nobody is in the opinion of shying away. I think everyone is aligned. So the third, any specific compliance under the consumer protection? Yeah, it is also answered. And then okay, are there any specific complaints? Okay, protection from financial frauds. Okay, protection from financial frauds is basic to consumers. So how you think this, in spite of existing legal framework and technological digital framework, why it is still not so expeditious, and what is the solution when enforcement agencies don't act in time and not properly equipped with? So the question is like, the question is loaded with answer itself, in my opinion. So anyone wants to take this question? So the question is,
Pandu, perhaps I didn't understand the question.
Yeah, I would like simplify the question for you. Protection from the financial frauds is basic to consumers, right? How think, despite this existing legal framework, we can ensure? I think the question, this person has a question that don't act. Okay, the solution of enforcement agencies don't act in time.
I think there was one aspect that I wanted to bring in when you were, I think, summarizing the entire process, and that perhaps ties into a certain extent with regard to this question, is that we can have all the laws that we want to, we can have all the regulation that we want to. The enforcement is obviously always a different ball game, and it is an evolving process. It's not something that we have greater amount of issues than the people to resolve them. So that's something that we will have to a certain extent, live with. But I think the important aspects that have been introduced in the new act, specifically the mediation process, specifically the internal redressal of grievances process that each company must have or provide for, those two, to my mind, will perhaps reduce the aspect of these issues. And secondly, then most importantly, something that is important through across each sector is education as an awareness. If the CCPA can discharge that obligation of spreading the awareness of the various options that are available to address your grievances without having to go to courts, and to educate the consumers about what their respective rights are, and provide for a collaborative mechanism whereby we are viewing this both as sellers and offerers of services, as well as the people who are receiving this, as a collaborative process rather than a process where we are at loggerheads with each other. That's when we will really be able to reach a resolution, whether it is financial frauds or financial aspects or otherwise, to my mind.
I think
Yeah, you were saying something. Sorry,
yeah, I think before Sneha, I just want to add, I think there is a good amount of a cyber security awareness required at this point in time. I mean, that is very important. Yes, Neha, you have.
No, that's exactly what I was also coming to, Pandu, that today, I mean, we always look at, what is the government doing? What are the regulators doing? What are the officers doing? What is the police doing? But I think from a financial fraud or any fraud perspective, we also have to ask ourselves as consumers, what are we doing to prevent being defrauded? So for example, I can say this from personal experiences. Regularly we get SMSs on our phones, we get calls from unknown numbers, trying to project as if they are calling from some bank for some details, or they are calling from some brand owner whose product you have recently bought. It's very easy to get these numbers, to get our phone numbers from various sources. Everything is publicly available when we freely give our phone numbers. So I think one of the first things that need to be done by the CCPA, and I completely second what you and Abhishek sir said, was that we need the CCPA to start having awareness campaigns to educate the consumers on how to identify basic fraud calls, basic phishing emails. I mean, we regularly get emails by somebody who's pretending and impersonating to be someone who's actually your known person, and saying that, oh, I'm in difficulty, can you do this, can you help me this way? And we get duped by such calls and messages. So I think that is one of the ways. I mean, the government is doing as much as they can by creating a legal framework to have the consumers' rights protected, but the consumers also have to kind of step up and become more aware about what kind of frauds are happening to avoid being defrauded in the first place.
Great answer. So we have one more question.
Time for Rajni to come back now on cyber. Remember
Yeah.
1986?
Yeah. Yeah, I think we should want a superhero to come and solve it.
Yeah.
So we have the last question of the Q&A. The question is, what security risk does e-commerce involve? This is a little narrowed question. It's about only security risk that e-commerce companies involve. Anyone wants to take this question?
So I think from a broad perspective, security risks, I mean, you have to disclose certain information about where you stay, what your financial details are, what your phone number is when you're purchasing products on e-commerce. So I think from that perspective, it is very important that before you actually enter into a transaction with an e-commerce company, a consumer should identify what are the payment gateways which are being used. Are they genuine payment gateways, reputed companies who have proper encryption methodologies available in place to secure your financial data? Are these companies which have just do a general check on any search engine to identify whether the e-commerce companies are reputed companies, or have there been in the past been complaints of fraud against that company? I think that would help allay any security concerns, because there are a lot of companies which are operating out of territories, globally, targeting consumers anywhere in any jurisdiction, where you end up spending a lot of money to purchase products, but the products never end up reaching you because of some issue or the other, and then you're running helter-skelter. So I think from that perspective, there are security issues when you disclose your financial information, your physical addresses, your phone numbers. But those security risks can be defrayed by just observing a bit of due diligence from the consumer's side.
I fully agree with you. Abhishek, Anubhav, you want to add anything to this?
No,
So I think, sorry, please, Anubhav, please go ahead.
Go ahead, Abhi. No, I think I would resonate with Sneha's view that I think while there are three aspects to it. One is the awareness, which we touched earlier, is the consumer due diligence itself when they are dealing with the entities, and third is the legislative and the enforcement framework. I think everything is catching on or are at different levels of maturity, but I think at this point of time, I think consumer diligence and awareness are more required.
Yeah. I think it's most important for the consumers to like do some amount of a diligence. That's very, very important. I have seen consumers for a consumer grievance where company have like responded saying, you will receive your refund in couple of days or 3 days, 7 days. They still tend to speak to the consumer care, and they randomly pick up an odd number by Googling, where fraudsters have published their different mobile numbers, and calling them and asking them, and end up losing all their amount, money in the bank. So this is so important for people to come up with little due diligence before they were to like really look up to e-commerce company to solve their certain risk, most importantly security risk. I think there is lack of legal framework. I think once this data protection law is in force, things will definitely improve. Apart from that, the enforcement of these fraud transactions and the complaints, cybersecurity complaints, is also not so helpful at this point in time. Things have to really move to a direction where there is good amount reduction in the number of these frauds. I think the Ministry of Home Affairs have come up saying there is a 500% increase in the online fraud during this pandemic situation. So the central government Home Ministry has also launched a website called cybercrime.gov.in, where consumers the people who have been defrauded can register their complaints. I'm not sure how effective that will be, but I'm sure government will at least will have a view of all the frauds so that they can take cognizance of it and come up with better legal framework to deal with that matters. With that, I would thank you everyone, Sneha, Abhishek, and Anubhav, for your precious insights on these subjects, and also for the participants participating in this, and Lex Witness for this organizing this wonderful session. Thank you so much.
And thank you, Pandu, for an excellent moderation of this very interesting topic. I think you held us together and led us into areas where I know you were the Sutradhar. You wanted us to answer in a particular way, and we hope we've complied with that.
Very well.
second that. Thank you so much, Pandu, for a wonderful session. Thank you.
Thank you. Thank you, Mr. Acharya. Thank you to all of our panelists for joining us this afternoon. It's a Saturday afternoon, and I'm sure everyone's really hungry. So thank you once again on behalf of all of us here at Lex Witness for joining us and sharing with us your insights. So with that, to all of our audiences, we have come to an end of the 2-day virtual webinar, and we thank you once again for taking out time from your weekend and joining us today. Thank you. With that, we'll close the webinar now. Thank you.
Thank you.
Thank you. Bye.
Bye.